All right, good morning, everyone. It is 9:30, so we will go ahead and begin. Let's go on the record, please. Good morning, Mr. Young. We are still with you. I will remind you that you remain under oath. And I believe that Mr. Grantmeyer has finished his cross-examination, and that Ms. Force is the next in line to cross-examine.
Excuse me, Chairman. I'm getting a lot of feedback.
I'm hearing the feedback too. Let's see if we can identify where it's coming from. Okay, Mr. Young, if you would go off mute and let's see if we can hear you.
This is Steve Young.
Okay, Mr. Young sounds good. So I will go back on mute, and Ms. Force, please proceed with your cross-examination.
Chair Mitchell, this is Kamal Robinson. Before you begin, will the commission be entertaining any procedural motions?
We can do that, Mr. Robinson. If you have such a motion for me, I'll entertain it at this time.
Thank you, Chair Mitchell. And good morning. On Monday, the company moved into the company's respective records, the company's Form E1 items, and neglected to mention that the companies filed a series of corrections and supplements to particular Form E1 items. At this time, we would like to move those corrections and supplements into the record, and I will list them if you would like.
Please do so.
Sure. So starting with DEC, we ask that the corrections to E1 item 14, E1 item 23, E1 item 33, and E1 item 38, all filed on February 14th, 2020, be moved into the DEC record and copied into the DEC specific record at the appropriate time.
Hearing no objection to your motion, Mr. Robinson, it shall be allowed.
Thank you, and I'll move to DEP next. So Chair Mitchell, we ask that the confidential supplement to Form E1 item 23 filed on November 19th, 2019, and the supplement to Form E1 item 14 filed on March 13th, 2020 be moved into the DEP record and copied into the DEP specific record at the appropriate time.
All right, Mr. Robinson, hearing no objection, your motion will be allowed. And I note that you've indicated that some of the evidence you've moved is confidential.
Thank you, Chair Mitchell. That's all I have.
All right, any additional motions before we get started this morning? Okay, hearing none, Ms. Force, you may proceed.
Thank you, Madam Chairman. Excuse me. Good morning, Mr. Young. I don't have any questions for you. Thank you.
Thank you.
All right, Mr. Trathan, my notes indicate that you are up next.
Yes, Chair Mitchell, Marcus Trathan for tech customers. I also do not have any questions for Mr. Young.
Okay, thank you, Mr. Trathan. All right, any additional cross-examination for Mr. Young? All right, hearing none, Duke, you may proceed with redirect if you have any.
Yes, just a few. Thank you, Chair Mitchell. Mr. Young, yesterday, Mr. Grantmeyer walked you through some potential options that the company could employ to address the coal ash issue. And what I'm focusing on is the lack of recovery and return on significant portions of prudently incurred costs, and is recommended by the public staff. Do you recall that?
Yes. Yes.
And ostensibly, in the wake of a potential credit downgrade, those examples include opportunity to access debt markets or issue or large equity issuances. Do you recall that?
Yes, I do.
And can you explain why those are not viable levers for the company to address the coal ash issue?
Yes, let me address that. Let me start with, there was dialogue around utilizing the Master Credit Facility, which is essentially a form of debt to get access to funds. And as I said yesterday, the Master Credit Facility is used for emergency situations. We didn't even use it in COVID. We used it back in 08, 09, that long, over a decade without utilizing it. That is not viable. All of those banks that are in the master credit facility would roll out and would not come back in. So that's not a viable source of capital for an issue such as this. The coal ash recovery is an ongoing issue. It's not an emergency. It's something that we've known about, been working with the DEQ about to resolve how to do it, what timeframes to do it. So lack of funding, appropriate funding, including financing costs and debt service funding, cannot be dealt with through the master credit facility. Another concept that's come up through the proceedings, I believe, is we'll just issue some equity and deal with this situation through that. The impact of this coal ash, mathematically, mechanically, of lack of return, just the lack of return, is 100 basis points drop in the FFO. It's been very clear from both agencies how they would treat this, and that's the result. The public staff proposal would be an even larger drop, which involves stretching it out, no return, and lack of recovery of some of the costs. Larger impact. So the question becomes, well, can you issue equity to just resolve that 100 basis point issue? It's far too large an issue just mechanically to solve with equity. It would take nearly $5 billion of equity. It is utterly infeasible to issue an amount of equity that large. When we issued equity back for Atlantic Coast Pipeline, a very clear singular issue of $2.5 billion in 2019, it was the largest equity issuance, non-deal, in the history of the utility industry. To suddenly say, well, just do it again and double it up is not feasible. The other issue is that qualitatively, a ruling of this nature, of lack of recovery of cost associated with an effort of this magnitude, $8.5 billion over many years, in compliance with state and federal regulations, would qualitatively change the threshold. I believe that Moody's and Standard & Poor's would raise the threshold from 15% to a higher level. So your needed move to get to maintain your credit rating is more than 100 basis points. It's more than 1%. It's probably closer to 2%. So therefore, the equity needed to solve that would go up by order of magnitude. It's not feasible to do that. That is not the appropriate manner to think about the solution to this issue.
Thank you, Mr. Young. One other question. Your testimony discusses how the company manages its fundamental financial operations. And so short of recovery and return on coal ash costs as the company has requested, are there any other options or mechanisms that could address these concerns, yet allow the company to preserve a healthy balance sheet and its positive credit metrics?
I do think there are tools that can help this situation. I heard some dialogue about a run rate earlier in the proceedings. And let me discuss this a bit. If you'll recall, initially in the previous rate case, we had requested a run rate to deal with coal ash. And that was denied by the commission. What a run rate does is it says, look, there's going to be an expenditure of X going on here. Let's put that amount in rates. So as the cash flows are being made to remediate the ash basins, the cash flows are coming in through rates. There's no need to finance at all there. Had the run rate been granted back there, we wouldn't have an issue because there's no need to finance. You're getting the funding necessary to do the work on a current basis. You don't have to borrow anything. But the commission overtly said in the previous order, we are not going to grant a run rate. We're going to force you to spend and defer those costs and seek recovery later. The commission acknowledged in the order, we realize that we're requiring you to finance this effort, but we will incorporate into rates the financing cost associated with the effort. So that's the basis of the ruling at that time. So we didn't get a run rate. We were forced to incur the financing cost. We've got $1.5 billion sitting on our balance sheet. over $1.5 billion of coal ash costs that we have expended, that we have not gotten into rates. Therefore, financing costs are required. Remember, we're cash flow negative. We don't have any cash we can draw upon. We are constantly in a state of building new assets, serving new customers that move into the area, and building new facilities to meet 17% reserve generation requirements. Those kind of things at costs that are higher than historical depreciated cost in rates. And that's what is typical of utilities. So we're cash flow negative. We got to borrow under this regulatory construct. And that's reasonable, assuming you're going to get full recovery of your cost, including financing costs. So a thought to think about going forward, incorporating a run rate is an effective tool. Now, we still got to deal with the $1.5 billion that sits on the balance sheet. But if you keep the structure that's currently in place in rates and then utilize run rate type concepts going forward, that will help minimize the financing cost and take this issue off the table.
Mr. Young, Chair Mitchell, I have no further questions. Mr. Young on redirect.
Chair Mitchell, Mr. Young was speaking and he was on mute at the end.
Mr. Young, you're still on. Okay.
I think I had completed.
Okay.
I was telling Mr. Heslin that I could not hear him. I think that was what I was saying.
Okay. Understood. Thank you.
Okay.
And Mr. Heslin, just for the purposes of the record, you have completed your redirect of Mr. Young?
Yes, Chair Mitchell, I have.
Okay, thank you. All right, we will entertain questions from commissioners. Commissioner Brown-Bland.
Yes. Mr. Young, yesterday you spoke to Duke's trading at 15 to 20% at a 15 to 20% discount. How long has that been the case?
That has been the case that started in 2019. We were trading at virtually no discount at the end of 2018. During 2019, we saw events occur. The DEQ order for full excavation of all ponds in April. We saw events at Atlantic Coast Pipeline and the Fourth Circuit Court, federal court, that were negative there. That continued. We saw a drop in early 2020 when the Dominion order on coal ash in North Carolina came out, and our investors, both debt and equity, were concerned about the implications of that order if it were put upon Duke. Those were the main issues.
And so, what are your metrics for the discount? What's the discount compared to?
What we look at is the price earnings ratio, the PE ratio, and that is the price of the stock divided by the estimated earnings, estimated by analysts, by experts in the field for a forward year, say 2021. That is the measure that our industry looks at. And there are estimates of our earnings based upon our own projections of forward earnings. But the price that the stock warrants based upon those earnings is low because there's a lack of confidence that we'll be able to meet those earnings profiles. So our price is depressed given our earnings profile because there's concerns primarily about the coal ash issue at this point. That's the measure that we look at.
All right. And so you attribute that, at least in part, to the regulatory environment, that discount?
It is concerns over the regulatory outcomes in various cases, primarily this case. It is, as I said, concerns about the coal ash, in particular, the disposition of coal ash, particularly given the Dominion order in light of its change from the previous order that we received.
All right. That's all I have right now. Thank you.
Commissioner Gray.
Thank you. Just a couple of questions, Mr. Young. Back on July the 21st, on page A2 of the Wall Street Journal, an article says Duke has been unable to use all the corporate research and renewable energy credits it accumulated because it has been using accelerated tax deductions for capital investments to lower its taxable income. And this is according to Dwight Jacobs, Chief Accounting Officer. The proposal, he said, which would be included in possibly the next economic relief legislation, would, quote Mr. Jacobs, would give us more cash today, and that would cause us to avoid borrowing money that we would otherwise have to borrow. He went on to say that Duke isn't counting on the money, however, but much of the benefits would flow to the regulated utilities customers over time through lower rates. The question is there an effort by Duke and others who are in this same category, that is, unable to use tax credits they haven't been able to use for years, to engage Congress in the next economic relief bill to allow that legislation to move forward to free up $1.8 billion for Duke? And I'm suggesting that 60% of your business is in North Carolina, so that'd be $1 billion that could be applied to the customer or to other issues. Your comments, sir.
Yes, I'm very familiar with that. Dwight reports to me, and I'm familiar with the issue. We certainly have extensive efforts through our Washington office to try to put those types of provisions in the next stimulus bill. I have certainly visited up in with the Treasury Department officials on these issues. And what we're trying to do is to be able to monetize, meaning turn into cash, various tax benefits that we've got. I mentioned yesterday that because of bonus depreciation, we are in a non-cash tax paying position. And that will persist for a few years. Then we'll emerge out of that and we'll be able to utilize these tax credits to reduce IRS bills, and that will be beneficial. We're trying to accelerate that capability. We have extensive efforts underway. And certainly getting a cash benefit of that nature would help displace the need for financing, and that's beneficial to us. It would not displace all the need. Our needs are far greater, but we're looking for everything we can find, and that's part of it. Yes.
And just as a follow-up, my understanding is other large corporations like Ford and Occidental Petroleum and some of the others are in the same, find themselves in the same boat. Is there an effort with your group to put together a strong effort to ask Congress to include this in the next stimulus bill?
Yes, there is organized efforts. We have organized efforts with Edison Electric Institute for our industry. We're also participating in manufacturers groups and other organized efforts to have cohesive lobbying issues. Those efforts are underway.
Thank you, sir. That's all.
Commissioner Clodfelter?
Yes, just a few. Mr. Young, good morning. Thank you for commenting at the end of your redirect testimony about the concept of a run rate. And I'm going to use a different term for it. I'm going to call it the normalization of an expense. That's really what we're looking at. Run rate's a fairly loose term, but we get the concept. For the commission to be able to take an ongoing expenditure and normalize that and include it in rates requires that we be able to determine that that expenditure is known and measurable on an ongoing basis. In 2017 and 2018, the company didn't have the ability to make that showing. You were still at a position where you didn't know what DEQ was going to require of you. You weren't certain where you were headed. You did not have field experience with bidding and contracting an awful lot of the expenditures. We're 3 years later now than we were in 2017 and 2018. My question is, do you believe the company is in a position today and has sufficient information to make a showing in these cases that the ongoing expenditures for coal ash remediation and coal ash closure are sufficiently knowable and measurable that they could be normalized and included in base rates?
Yes, I do, Commissioner. That is a very valid point, and I certainly don't mean to impugn the prior commission's ruling. Very valid, based on the facts in front of them. But we certainly have probably more experience than any utility in the country about coal ash remediation. We have completed excavation at the 4 high priority sites. We did that ahead of schedule, under budget. So I think we have a unique set of capabilities to understand what the future costs could be in this area. We've been doing it for years. We've completed basins, as I mentioned. So we have a depth of experience across our footprint that I think is very, very well utilized here.
Thank you, Mr. Young. That's essentially, I think you know where I'm going to be asking questions of some subsequent witnesses, so you'll have a chance to go back and be sure they're prepared to make that showing. We'll deal with those witnesses when they come up, but I thank you for that general overview. Appreciate it.
Thank you.
Commissioner Clodfelter, anything further from you? Okay. Commissioner Duffley.
Good morning. To follow up on what Commissioner Clodfelter just asked of you, I'd like to direct your attention to Newland Redirect Exhibit 2. I believe it's Exhibit 2. It was pre-marked as Deck Depth Exhibit 15. It's the Moody's credit opinion dated March 30th, 2020.
I'm familiar with it. They'll work to get it in front of me, but you can go ahead. I'm familiar with it.
So, again, going back to the 2017 opinion and the request for a run rate in that case, at that time, there was probably only 1 year's worth of cost or experience with coal ash remediation. Is that accurate?
It was certainly more narrow. That's correct.
And so on the bottom of page 3, Moody's talks about coal ash expenditures and the future expenditures of the company. And it starts out, you see the heading, capital expenditures are expected to moderate somewhat in the near term, but remain substantial. That's kind of a little bit darker heading.
The report I'm looking at says capital expenditures expected to remain elevated. I'm looking at the October 31.
This is the March 30th.
March 30th, 2020. Okay, hang on. Moody's. I've got it now. Hold on, please. Yes, I see what you're looking at. Yes, the capital expenditures are expected to moderate. Yes.
Okay, so see that last paragraph where it's starting with payments of coal ash?
Yes.
Okay, so basically this paragraph is saying that so halfway through it says in 2020 we anticipate environmental spending inclusive of coal ash remediation to be about $450 million before subsiding to an annual rate of about $200 million in 2021 and beyond. Would you agree with that statement?
Yes.
So do you feel like
for that utility? Yes, that's correct.
For this utility, okay. And so the coal ash expenditures based upon your settlement with DEQ are going to be more known and measurable moving forward?
Oh yes, I think so. As I mentioned, we've got a lot of experience with this. We have excavated 4 sites, mini basins, so we know how that works, and we've completed it. We're underway on many other basins. We've got an organization that is stood up to do this work, very capable engineers, very experienced people. So I do think we have great experience here.
Okay, thank you. And I have some clarifying questions just about your rebuttal testimony. On page 20, you probably don't need to go to the testimony, but on page 20 of your deck rebuttal testimony, you state that investors are concerned with the company's significant amount of investment at risk for recovery in this and other NCUC dockets. What are the other NCUC dockets? Is it just the DEP rent case, or are there other dockets as well?
I think it's referring in general to the Dominion order and what was at stake there. So it's broader than just ourselves. It's just a general statement about the proceedings in the state.
Okay, thank you. And then on page 18 of your deck rebuttal testimony, you quote a Moody's report and that states historically strong financial coverage metrics are being impacted by storm activity, coal ash remediation spend rate, and delayed rate relief. And then it goes forward about regulatory lag. But when Moody's refers to the coal ash remediation spend rate, do you interpret that to suggest that Duke needs to slow down their spend per year? And can you even do that if that's what that means with the DEQ settlement?
I don't think that's what it means, Commissioner. We certainly have no intent to slow down spend because of any credit report or anything of that nature. We've got a job to do based on our settlement with DEQ regarding these ash basins, and we're going to go after that very aggressively as we have done to date. So I can assure you of that. I'm not sure specifically what your question pertains to, but I will say this: there is an issue of concern in the industry by all the rating agencies on lag. And it is heightened a bit for the Carolinas because there is less rider mechanisms, forward-looking multi-year rate plans, those kind of things. And what they look at is that you've got $900 million of storm cost on your books for now a couple of years, and it's going to be another year before you get the securitization rolling. You got $1.5 billion, north of $1.5 billion of coal ash, and that's growing every day as we remediate basins. You've got over $1 billion on Western Carolinas modernization. And again, in the Carolinas, it's the type of regulation where you have to spend, defer, or in some cases not even defer, file, and go through all those processes before recovery comes in. And that's the concern. Are you dealing with lag? You've got it on a number of fronts. So that's just really the basic issue they're speaking to.
Okay, so it's maybe the actual amount of the spend. So this could be referring to when you're looking at the amortization, whether it be 3, 5, 10, 27 years, it's that level of spend is an important factor, the amount.
That's correct. That's correct. I mean, we're spending every day to get it done. The spend is higher in the early years than the later years. And the recovery mechanisms are delayed for when they start, and then they're spread from that point forward. And now some interveners are talking about not giving the financing costs as we go forward. So that lag builds up, and that's the concern the rating agencies have, and our equity investors have it as well. Both sides are concerned with this issue.
Okay, thank you for that description. So then in your testimony yesterday, if you could help me understand this a bit more, you mentioned that your stock price is 20% lower than your peers. Could you kind of explain that a little bit more? And when did that begin?
Yes, what we look at in our industry is the PE ratio. That's price divided by earnings. And price is the stock price at a given point in time. The E, the earnings, the denominator is typically the upcoming year, the estimated earnings for the upcoming year. We give a forecast of what our earnings are. It typically gravitates to where our forecast at a given point in time divided by the earnings estimate for an upcoming year, typically the prompt year. And you compare that to all of the other utilities out there. We're all very similar in our business profiles. And that ratio is very low for us. And that is because our earnings projection is stable and solid, but the investors do not have faith we will be able to earn at that level. So the price gets depressed, and our price is depressed relative to our earnings profile by 20% compared to our peers. Now, why are they concerned? The big issue that they're concerned with is the coal ash issue. What does it portend for the future? This is a big issue in and of itself, but this is a change in the DEQ that was deemed to be reasonable, prudent, in the public's best interest. This is troubling for us, so the price gets depressed. And that makes it difficult for us to go out and do the equity arm of our financing, and that's been going on during 2019. We have to issue far more shares to get the funds we need. That puts pressure on the magnitude of the dividend and carries through to other things. So that is the fundamental mechanics behind the issue.
And so it began probably then when the coal ash, like 2015, 2016.
Well, the issue began really in 2019.
2019.
It really began. In 2019, the DEQ came out with an order that says you will excavate all basins. And that's different than what is seen throughout around the country, but that's their order, and we have worked to settle and agree around that, and that's fine. But that was an issue that started to show some concern because of the magnitude. The price depression also occurred when the Dominion order was issued by the North Carolina Commission that said effectively there will be no return on these costs. And that, given our situation where the magnitude of the cost is $8.5 billion, far greater than Dominion's North Carolina piece, that concerned both debt and equity investors significantly.
And then I think I only have one more question. I also heard you state in your testimony yesterday that all your other peers that are dealing with coal ash remediation costs are receiving a recovery of and on. And you mentioned, I believe, Indiana, Georgia, and Florida. Do you know if there are any other utilities, other states as well, that are dealing with this issue, that are receiving recovery of, full recovery of, and then full recovery on?
Virginia has in place mechanisms that provide full recovery of and on as well. I believe there are other states, but those are the ones that come to my mind.
Okay, thank you. I don't have anything further, Chair Mitchell.
All right, Commissioner Hughes.
No questions. Thank you.
Thank you. Commissioner McKissick.
Thank you, Chair Mitchell. I have a couple of questions. And Mr. Young, in terms of the totality right now, as you know it, in today's dollars for the magnitude of the coal ash issue to be resolved, I mean, I heard you state in response to Commissioner Duffley's questions a while ago, you used the number 8.5 billion. Now, is that the number that Duke is looking at this time?
Yes, that's the total cost to comply with the settlement with DEQ to excavate roughly 75, 80% of the basins, and then cap in place the other portion. Those are rough numbers in my mind, but that's the cost over that time frame to do all of that work, $8.5 billion.
And the time frame in terms of years at this point in time, refresh my recollections as to what that looks like.
The heavy spend is over the next 10 years, but it goes on beyond the next 10 years with various efforts for at least another 10 to 20 more beyond that.
All right. Now, I know you've discussed the run rate, and I think Commissioner Clotfelter was very articulate in discussing the lack of data that was available during the last rate case. But as it presently stands, other than the run rate, I mean, have you explored or thought of any other mechanisms that might be open to address this issue? I mean, the idea of a rider I've heard come up from time to time, but give me your reaction to that concept, but more importantly, what are the other tools that might be available as mechanisms to address this debt moving forward?
Well, certainly, as I mentioned, a run rate can be a useful tool. A rider mechanism is an extremely useful tool as well. In Indiana, there's an environmental rider that these costs are being run through. And the advantage of a rider mechanism is it has its own set schedule of review of the specific issue. It allows for a more coordinated understanding of when that mechanism dollars will flow through and be examined and be incorporated into the rates. And so it's easier to plan the financing around that type of mechanism. A rider mechanism, I think, is a superb way to deal with it. A multi-year rate plan where you can schedule cost increases ahead of time that allows you to finance it, gives confidence to the markets. That's another tool as well. Those are some of the fundamentals that we've thought about.
All right. Now, assuming a worst case circumstance and a decision was rendered that was more consistent with what occurred in Dominion, what do you think would impact? I mean, obviously Moody's is sitting here reviewing decisions that are made as they come along. How do you believe that it would impact your credit rating with Moody's? I mean, how many notches would it be displaced from where it is today? I mean, what would you see as a potential outcome?
I think certainly if we got what I'll call the Dominion order, I think both Moody's and S&P would knock the holding company down a notch. They would knock DEC and DEP down a notch. At S&P, they use a family rating. So at S&P, the parent, the holding company, would move down a notch, and all utilities underneath it, Florida, Indiana, all would move down a notch. That is what I feel would happen. Additionally, the thresholds would change because the thresholds are based upon quantitative and qualitative assessment of the regulatory environments for utilities. And it has been clear to me that they look for predictable, consistent regulation, and they look for full cost recovery, including financing costs for reasonable and prudent costs. So I think the thresholds would then increase, and that would put us so that it would be very difficult to get back to the rating levels that we're at, as I mentioned earlier. And it would change the threshold for the next rating down. And you have to be very careful. If we were to move 2 notches down, the world changes significantly for us. 2 notches down from the levels we're at, the commercial paper markets are very narrow. We couldn't use commercial paper to ride through COVID and to time when we go into the long-term debt markets. And the equity side is already quite nervous about things. They being at the end of the line, feel it first, and that's why the stock price has been depressed. That would further continue to be a further problem.
Okay, now let me ask you this, because as it presently stands, you have a great credit rating. But I mean, there are other peers in the utility field or investor-owned utilities that do not have the credit rating that you have today, that don't appear to be significantly adversely impacted by having a Moody's rating that is less as impressive as yours is. So, I mean, they are competing and they are doing what they need to do in the market. They are able to borrow. I mean, they seem to have addressed concerns of their investors as well. So, I mean, can you help me understand how they can compete in that environment, but it would be more challenging for Duke to do so?
You're correct. There are other utilities that are operating at a notch lower than we are at. That's correct. And I don't want to say we could not operate at one notch lower. Others have done it. We would have to do it. What I do want to say is we can't solve this with new equity. We cannot solve it with drawing down a master credit facility or any of these other things. If this order comes out, we drop a notch. That will start to limit flexibility in terms of getting to the markets in the timely fashions we need, the use of commercial paper. We can operate in that environment. And that's why we said on the earnings call, we can't issue equity to solve this situation. So that needs to be known. So we would operate there. But it needs to be understood that we would be one notch closer to a level where we would be severely constrained in doing the things we need to do. And we're sitting here in a hurricane-prone area. We're running 11 nuclear units in the Carolinas. We have a profile that requires liquidity. And I just want to make sure the commission understands the magnitude of all of these issues.
Thank you. I don't have any further questions this time, Chair Mitchell. Appreciate your candidness that you've shared with us during your testimony.
Thank you very much.
All right, questions on the commission's questions?
Chair Mitchell, on behalf of the company, I did want, in response to the commissioner questions, to note that the company, as a part of the settlement and in response to the commission's request, will file on Friday estimated coal ash spend by year through 2065 for DEP and through 2078 for Duke Energy Carolinas. I just want to note that. And then I have one question for Mr. Young. Mr. Young, Chair McKissick asked you questions about other utilities operating below as far as their credit metrics. Do other states in where these utilities may operate have other mechanisms that are more modern mechanisms as far as recovering ongoing costs than say in the Carolinas or other territories where, well, for our purposes in the Carolinas?
Yes, they do. In Virginia, they have a separate mechanism dealing with coal ash. Dominion operates at a lower credit rating. Other utilities as well and have mechanisms typically for grid riders, for coal ash, environmental spend riders. That's correct.
Madam Chair.
And I apologize, Chair Mitchell, for going first. I should have allowed interveners to ask before me.
All right, additional questions on commission's questions. Public staff.
This is Bill Grantmeyer again. Commissioner Gray asked an excellent question regarding some legislation to get that 1.8 billion in credits that you could get. Do you remember that?
Yes, I do.
And yesterday you testified, and you may have reiterated it again today, that Duke is not paying any cash taxes, actually having to pay taxes to 2027. Is that correct?
Yes, that's correct.
Now, if you were successful in getting that legislation through, that would give you an extra 1.8 million in credits, and that would extend the time that you do not have to pay taxes beyond 2027. Is that correct?
No, not necessarily. It depends on the structure of what is done in the IRS rules. What we're looking for is to be able to monetize the tax credit on a more current basis. We're doing that now for alternative minimum taxes. That's baked into our plans. And basically, the IRS writes a check, the Treasury Department writes a check to the company. And that becomes cash used for general purposes. And that's the benefit of it. So instead of waiting until you've got taxable income in several years and then reduce that tax payment to the IRS in several years, just have the IRS write you a check now. You won't have the credit to use in the subsequent periods, but you'll get the benefit of the funds now. That's the concept that is being looked at. And whether they'll do it or not remains to be seen. To what credits they'll apply it to remains to be seen. But we've got efforts underway.
And McKissick, Commissioner McKissick asked you about downgrade, how many levels you get down. Isn't it true that Duke Energy Carolinas in an AA2 is one of the very, very highest of all the electric utilities?
Being our largest utility, it is higher rated. Again, we're in a storm-prone area and we've got nuclear facilities, so we need that liquidity. But yes, that's correct.
And if they were downgrade, and Duke Energy Progress is AA3, one grade below, is that correct?
Yes, they are lower. I'm not sure if it's 1 or 2 grades, but they're lower.
And so if Duke Energy Carolinas went down 1 grade, they would be AA3, which is the next lowest grade, correctly? Is that correct?
I think that's correct.
And there was testimony the other day that Duke Energy Carolinas embedded cost of debt is approximately 40 basis points greater than DEP or Duke Energy Progress. Do you agree with that's approximately correct?
I'm not familiar with that information. I haven't looked at it in that fashion, so I'm not familiar.
But Duke Energy Progress, as we said the other day, I think on August 20th of this year, was able to issue $700 million in 30-year bonds at the rate of 2.5%. Is that correct?
Yes, I believe that's correct. We've been able to take advantage of the low rates across our footprint. And again, with the Fed stepping in and saying we're going to backstand commercial paper, we're going to backstand corporate bonds, that has certainly stabilized the markets. But I don't know how long they're going to be able to do that. And I don't know when the economy is going to be able to overcome COVID, when this situation is going to calm down. And that's what we need to be concerned with, not just a point in time. We have to look broadly. We're going to be in markets for years to come, given the requirements to respond to hurricanes, to run nuclear plants, to handle the new customer growth in the Carolinas. And it's going to require a lot of spending capital. We're going to be in those markets a lot. And you can't just look at a data point. And I just want the commission to understand the implications of moving down in the credit ratings. And I don't want the commission to forget the equity side, because we got to finance half with the equity side, and we are disadvantaged now because of the current concerns over recovery of costs.
But if Duke Energy Carolinas were to go down 1 grade, that would be the same grade that Duke Energy Progress is now. And with Duke Energy Progress getting such a great rate on such a large issuance, it would appear that Duke Energy Carolinas is not going to be materially impacted. Would you agree with that?
No, I would not agree with that. I'm talking about the longer term here. You can't look at one issuance in 1 month and say, this is going to be the world forever. These things bounce around. We did the issuance in February, March at Indiana, and a week later, utilities couldn't issue. That's how quickly it can change. I don't know that the government's going to be able to backstand corporate debt forever, as I said yesterday. I don't know that COVID is going to be solved. I don't have that crystal ball. These markets can change. And you can't sit there and look at one issuance and say, this is what the world's going to be like as we go down the road. It could be another financial crisis. There could be health issues. There could be global concerns with China, with Russia. There could be political issues that we see. There's a tremendous amount of uncertainty underlying the economy. And that's what I'm looking at. That's what I'm hearing about from the people that we go to borrow money from.
Isn't it true that Duke Energy Progress has had one notch below Duke Energy Carolinas for several years now, at least?
I think that's correct.
But yet, even though they're below, they still have a lower embedded cost of debt. And therefore, obviously, would you agree that timing of the debt issuances materially affects your embedded cost of debt?
Timing is certainly important, and flexibility. Timing comes with flexibility. The flexibility to be able to know that you can ride the commercial paper markets so that if there's an issue globally that's pushing prices up, and you can ride the commercial markets longer and find the right time, that is incredibly beneficial over the long term. So it's not just a matter of, hey, we need money, let's go out tomorrow, and wherever it's at, hopefully it's low. And to be able to have that flexibility, you need to have a stability and a confidence of cost recovery beneath it. We can talk about this issuance versus that issuance. Overall, well, we have solid credit ratings. We have flexibility in the markets. That has enabled us to finance very efficiently. That's part of why our rates are regional averages, and that will continue. But I just want people to understand the implications of taking a narrow view of this in terms of the credit ratings, its impact on debt and on equity. We're already feeling it on the equity side.
Public staff has no further questions.
All right, Ms. Force, it looks like you are ready to ask questions. Ms. Force, you are muted.
I'm sorry, I probably had my mic open earlier. Can you hear me now?
Yes, please proceed.
All right, Mr. Young, I do have just one question, or one series of questions. You talked earlier about uncertainty that investors have, and wanting that they prefer not to be uncertain about what's to come. Did I understand you correctly on that point?
Oh, yes, they look for predictability in businesses and regulation around businesses.
So I'm assuming, and please tell me if I'm wrong, that in the case of the Atlantic Coast Pipeline, that is not something that Duke is indicating to its investors that it's going to defer costs on for recovery from its ratepayers. Am I right about that?
Oh, that's correct. Yeah, we have not made any claims of that nature and will not do that.
And I think you talked yesterday about the certainty that there's some advantage from the perspective of the investors, then that's an issue that they don't have to have uncertainty going forward about.
Well, yes, prior to the cancellation of the project, there was unquestionably uncertainty in investors' minds, given the legal and regulatory challenges that we were seeing there. Obviously, abandonment takes that away. Now you have to readjust going forward. We won't have that valuable piece of infrastructure in Eastern North Carolina, and we will work around that. But that piece of uncertainty is now gone.
Okay, sure. And I think you were indicating that before. Do you have any sense of how long it might be before there's an adjustment? There's not going to be a downgrade so far as you know, in the Duke Energy operation?
No, we're on stable ratings right now.
Okay.
The regulators have said that, but they have also, the rating agencies have said that. But they've also said that that is based upon the presumption that the regulation going forward will be constructive as it has in the past. And regarding the coal ash, if the costs are required to be deferred and recovered then in subsequent rate cases, they're looking for a return of and on as being the continued mechanism in place. What they've communicated to me is that if that changes and to a mechanism like the Dominion order, for lack of a better term, then I think the rating will change.
And as I recall, at the time that there were criminal penalties that were applied to Duke for the operation of its coal ash ponds, and $100 million in penalties were applied. None of that was ever, there was never any attempt to defer any of that money, or there was no indication that that would be recoverable. Isn't that right?
Chair Mitchell, at this time, I'd object to that question. That doesn't pertain to anything that was raised by the commissioners today. I don't see how that's follow up on commissioner questions.
Ms. Forrest, can you help me understand which commissioner's question that your question relates to?
We've had quite a few questions about the impact of cost recovery for coal ash ponds and how that affects Duke's status with the credit markets. And I'm asking whether in this instance, several years ago, when there were criminal penalties, Duke sought deferral and indicated to its investors that those costs would be deferred for later recovery.
All right, I'll let the question, I'm going to overrule the objection, Mr. Heslin. I'll let Ms. Forrest proceed with the question, but going forward, please tailor your questions to Commission's questions, Ms. Forrest.
We have not sought recovery in rates related to anything related to the cleanup or penalties associated with Dan River. That's the basin that the spill occurred at. And we have complied with all regulatory impacts for that. There's witnesses that can discuss that in more detail. We have not sought recovery for that incident that occurred in 2014. This is dealing with coal ash recovery, basin remediation in compliance with the DEQ.
And the reason I raise that is the point is that at the time in 2015, when Duke began deferring costs, it asked the commission for an accounting order that would allow the deferral of those costs rather than writing off the asset retirement obligation associated with coal ash costs that it was anticipating going forward. Am I right?
Well, certainly when it became clear from state and federal rules about what to do with coal ash remediation, we requested the accounting order, which is typical for large expenditures of this nature. And we received it, we began deferring it. But we did not put into that deferral anything associated with Dan River cleanup, penalties, etc.
Understood. But that deferral and the proceedings that have followed, that is part of what's created the expectation of investors that you would be including that in your revenues going forward. Am I right?
Well, certainly. The environmental costs have been a part of our business for decades, whether it's sulfur dioxide in the 90s and 2000s, NOx in the 90s and 2000s, whether it's spent nuclear fuel from the 80s forward. It's part of running these big machines and generating energy every day. So when this issue came up, like many other environmental regulations, when it was clarified as to what needed to be done, we began putting plans together for the spending and the estimates of the cost. We've gotten more experienced at that, obviously, and we sought an accounting deferral order, and that was put in place. It's typical in our industry to utilize these types of mechanisms.
And in this case, we're talking about coal ash that's been accumulating over many years, right? And now it's Duke's efforts to take care of disposal ultimately.
Yes, the plants, many are
Mr.
still.
Mitchell, I want to renew my objection. I mean, coal ash was a subject that was covered by the commissioner. That's obvious, but these questions are not specifically tailored to follow up on any of the examination by the commissioners. Ms. Force had the opportunity to cross-examine this witness. She did not do so. And these questions are very, first of all, there's a lot of argument in them. And so the way that they're being posed also leads me to believe that they are not in any way tailored or responsive to what the commissioners asked Mr. Young in their questioning.
Ms. Force, please respond.
I don't agree with Mr. Heslin, but I don't need to pursue this. I can end at that point.
Okay.
I won't ask any further questions.
All right. Thank you, Ms. Force. All right. Any additional questions on commissioners' questions? All right. Hearing none. Mr. Young, I believe we have come to the end of your testimony. I will entertain motions, Mr. Heslin.
Yes, Chair Mitchell. Duke Energy moves that Mr. Young's marked exhibits be admitted into evidence, specifically that the exhibits marked as Young rebuttal exhibits 1 through 7 be entered and copied into the DEC case, docket number E7 sub 1214, and his exhibits marked as Young DEP rebuttal exhibits 1 through 8 be entered and copied into the DEP case, docket number E2 sub 1219.
Hearing no objection, that motion is allowed.
The public staff would move that public staff Young rebuttal cross exhibit 1 be entered into the consolidated record as pre-marked.
Hearing no objections, Mr. Grantmeyer, your motion is allowed. All right, and with that, Mr. Young, we appreciate your testimony and you are dismissed. Thank you.
Thank you.
All right, at this point in time, we will now transition into hearing from the parties on matters related to the EDIT. And I believe, Duke, you may call your witnesses.
Good morning, Chair Mitchell and members of the commission. I'm Molly Jagannathan here on behalf of Duke Energy Carolinas and Duke Energy Progress. And the companies would like to call Carl Newland, Jane McManus, Kim Smith to testify as a panel on the topic of excess deferred income taxes.
Okay, good morning. I'd like to go ahead and get you all under oath. Do you affirm that the testimony you shall give in this proceeding will be the truth, the whole truth, and nothing but the truth? I do.
I do.
Welcome back, Mr. Newland. I think we've already moved all your testimony into the record, so I'll go ahead and start with Ms. McManus. Ms. McManus, would you please state your name and business address for the record?
Yes, my name is Jane McManus. My business address is 550 North South Tryon Street in Charlotte, North Carolina.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas, and I'm a director of rates and regulatory planning.
And on September 30th, 2019, did you cause to be pre-filed in docket number E7 sub 1214 direct testimony consisting of 42 pages as well as 4 exhibits to that testimony?
Yes, I did.
And on October 23rd, 2019, did you also cause to be filed in the same docket corrected direct testimony consisting of 42 pages for purposes of fixing a formatting error that was discovered after the filing of your original direct testimony?
Yes, that's correct.
And on February 14th, 2020, did you cause to be pre-filed in the same docket supplemental direct testimony consisting of 13 pages, as well as McManus Supplemental Exhibit 1 and Ms. McManus Supplemental Exhibit 4?
Yes.
On March 4th, 2020, did you cause to be pre-filed in the same docket rebuttal testimony consisting of 45 pages, as well as 3 exhibits to your rebuttal testimony?
Yes, I did.
And on March 25th, 2020, did you cause to be pre-filed in the same docket settlement testimony consisting of 7 pages?
Yes.
And on April 6th, 2020, did you cause to be pre-filed in the same docket supplemental rebuttal testimony consisting of 9 pages and 4 supplemental rebuttal exhibits?
Yes.
And on July 2nd, 2020, did you cause to be pre-filed in the same docket second supplemental direct testimony consisting of 9 pages, along with McManus second supplemental exhibits 1 through 3 and McManus second supplemental exhibits 1S through 4S?
Yes, I did.
And on July 31st, 2020, did you cause to be pre-filed in the same docket second settlement testimony consisting of 6 pages, as well as 4 exhibits to that testimony?
Yes.
And now, Ms. McManus, I believe you have 1 correction to your pre-filed corrected direct testimony on page 34, line 5. Can you please let us know what that correction is?
Yes, on page 34, line 5, the number 7.5 should be changed to 6.5.
Thank you. And do you have any other changes or corrections to your pre-filed testimony or exhibits?
No, I do not.
And with the correction you just noted in your corrected direct testimony, if I asked you the same questions today, would your answers be the same?
Yes, they would.
Okay, and finally, on August 6, 2020, did you cause to be pre-filed in docket number E7 sub 1214 joint testimony with J. Oliver in compliance with the Commission's order requesting information relating to the company's grid improvement program consisting of 17 pages along with 3 exhibits to that joint testimony?
Yes, I did.
Okay, I will wait for Mr. Jeffries to move the joint testimony and exhibits into the record after he's had the chance to confirm that Mr. Oliver doesn't have any changes. But I just want to ask you, you do not have any changes or corrections to the joint testimony or exhibits you filed with Mr. Oliver, right?
I do not.
Okay, thank you. Chair Mitchell, I move that Ms. McManus's pre-filed corrected direct testimony, supplemental direct testimony, rebuttal testimony, settlement testimony, supplemental rebuttal testimony, second supplemental direct testimony, and second settlement testimony be entered into the record in this proceeding, and further move that this testimony be copied into the record as if given orally from the stand in the Duke Energy Carolinas rate case dockets at the appropriate time.
Hearing no objection to your motion, it will be allowed.
Thank you. And Chair Mitchell, I would also move that the exhibits to Ms. McManus's pre-filed testimony be marked for identification as pre-filed.
Your exhibits, her exhibits will be so marked.
Thank you. Now I'll turn to you, Ms. Smith. Would you please state your name and business address for the record?
Yes, my name is Kim Smith, and my business address is 550 South Tryon, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
I am employed by Duke Energy Carolinas as Director of Rates and Regulatory Planning, and I'm testifying on behalf of Duke Energy Progress.
Thank you. And on October 30th, 2019, did you cause to be pre-filed in docket number E2 sub 1219 direct testimony consisting of 46 pages as well as 5 exhibits to that testimony?
Yes.
On March 13th, 2020, did you cause to be pre-filed in the same docket supplemental direct testimony consisting of 14 pages, as well as Smith Supplemental Exhibit 1, Smith Supplemental Exhibit 2, and Smith Supplemental Exhibit 4?
Yes, I did.
On May 4th, 2020, did you cause to be pre-filed in the same docket rebuttal testimony consisting of 44 pages, as well as 5 exhibits to your rebuttal testimony?
Yes.
On June 2nd, 2020, did you cause to be pre-filed in the same docket settlement testimony consisting of 11 pages as well as 4 exhibits to that testimony?
Yes.
On July 2nd, 2020, did you cause to be pre-filed in the same docket second supplemental direct testimony consisting of 9 pages, as well as Smith's second supplemental exhibits 1 through 3 and Smith second supplemental exhibits 1S through 4S?
Yes.
On July 9th, 2020, did you cause to be pre-filed in the same docket corrected second supplemental direct testimony consisting of 9 pages, as well as corrected versions of your second supplemental exhibits?
Yes, I did.
And on July 31st, 2020, did you cause to be pre-filed in the same docket second settlement testimony consisting of 6 pages, as well as 4 exhibits to that testimony?
Yes.
Do you have any changes or corrections to any of your pre-filed testimony or exhibits?
No, I do not.
And if I ask you the same questions today, would your answers be the same?
Yes, they would.
Okay, and finally, on August 6, 2020, did you cause to be pre-filed in docket number E2 sub 1219 joint testimony with Jay Oliver in compliance with the commission's order requesting information relating to the company's grid improvement program consisting of 17 pages along with 3 exhibits to that joint testimony?
Yes.
And again, I'll wait for Mr. Jeffries to move that into the record after he's asked Mr. Oliver the same questions. But just to confirm, you do not have any changes or corrections to the joint testimony or exhibits you filed with Mr. Oliver?
No, I do not.
Okay, thank you. Now, Chair Mitchell, I would like to move that Ms. Smith's pre-filed direct testimony, supplemental direct testimony, rebuttal testimony, settlement testimony, corrected second supplemental direct testimony and second settlement testimony be entered into the record in this proceeding, and further move that this testimony be copied into the record as if given orally from the stand and the Duke Energy Progress rate case dockets at the appropriate time.
Hearing no objection, your motion will be allowed.
Thank you, Chair Mitchell. I would also move that the exhibits to Ms. Smith's pre-filed testimony be marked for identification as pre-filed.
The exhibits to her testimony will be so marked.
Thank you. And Ms. McManus, I believe you drew the short straw. So could you please read the summary that you and Ms. Smith prepared on excess deferred income taxes?
Yes. One of the key issues in this case is the time period over which the company should flow back excess deferred income taxes, EDIT. Essentially, money previously collected from customers for future tax liabilities at the then prevailing tax rate that needs to be returned to customers because the actual taxes to be paid will be at a lower tax rate. No one disputes that these funds rightfully belong to customers and should be returned to them as soon as reasonably possible. In determining what is reasonable time period, it is important to take into account the cash flow concerns noted by Witness Newland, as well as rate volatility. Both the time period as well as the impact of EDIT on rate base are factors in rate volatility. EDIT amounts are a reduction in rate base. As these amounts are refunded to customers, rate base will increase. The more quickly unprotected EDIT is returned, the more quickly rate base will increase, thereby increasing volatility in customer rates. Accumulated deferred income taxes, ADIT, are income taxes the companies have expensed for accounting purposes and collected from customers, but will not need to pay the IRS until some point in the future. Because the companies have use of this cash for a period of time until it must pay the IRS, the ADIT is included as a reduction to rate base and is a source of financing for investments to benefit customers, poles, lines, generating plant, etc. With the change in the federal tax rate from 35% to 21% in 2018, resulting from the Tax Cuts and Jobs Act, or Tax Act, the amount of income tax that the companies must pay the IRS in the future has been reduced and must be remeasured. At the end of 2018, the companies calculated this reduction and the difference was reclassified to EDIT, which is a reduction to rate base. Instead of having an obligation to pay the EDIT amount to the IRS in the future, the companies now have an obligation to refund it to customers. Like the EDIT that results from the reduction in the federal corporate income tax rate, there are EDIT balances that resulted from the reduction in the North Carolina state corporate tax rate from 3% to 2.5%, effective January 1, 2019. The companies and the public staff have agreed to several terms addressing the return of state and federal EDIT to customers. Protected federal EDIT. There are specific IRS requirements governing the flowback period, and we have agreed that these amounts should be returned to customers through base rates. Unprotected federal EDIT. We have agreed that these amounts should be returned to customers through a levelized rider over a 5-year period. North Carolina EDIT. We have agreed that these amounts should be returned to customers through a levelized rider over a 2-year period. And deferred revenues related to the provisional overcollection of federal income taxes, we have agreed that these amounts should be returned to customers through a levelized rider over a 2-year period. Additionally, if state or federal income tax rates happen to change again during the respective flowback periods, the companies may, under certain conditions, propose to reflect the effect of any future tax rate change on the remaining EDIT balance. This concludes our summary.
Thank you, Ms. McManus. The panel is now available for cross-examination.
Okay, thank you. My notes indicate that the Attorney General's office is the only party with cross-examination, so Ms. Force, you may proceed.
Can you hear me now?
We can hear you.
Is Mr. Newland, you've already been sworn and your testimony is already in the record, right? I thought you were on the panel.
That's correct.
Just for my clarification. Okay, good morning. Thank you. I have some questions about the tax rider, and thank you, Ms. McManus. Your summary gave a good background on what these amounts are from. I think you also indicated when you talked about what we call EDIT and the North Carolina and the federal amounts, and there's also the amount that was collected for a time in, before rates were changed, I believe, and incorporated the 21% federal tax rate. You mentioned that as well, I think, right?
Yes.
That's the third one. And you said that the federal is going to be under the proposal with the public staff, that would be returned over 5 years, and the other two items would be returned over 2 years.
That's correct.
For clarification, would you agree with me that the amount of federal EDIT that is being returned is approximately $1.03 billion? That's the amount to go back to Duke Carolina's customers?
It's a little over $1 billion.
Okay. And the North Carolina EDIT is roughly $34.3 million. Does that sound right?
Yes, that sounds about right.
I'm getting these numbers from your supplemental rebuttal exhibit 4, page 1 for reference. And the deferred revenues, I think they're called, were about 121 million for the DEC.
That's right.
Amount. Okay. Now, by comparison, I didn't find it in your exhibits, but according to Mr. Piro's second settlement exhibit 4, the amount that Duke is requesting as an increase in base rates after the settlement is 414.4 million per year. Is that right?
Yes, that's correct.
Okay. And then Ms. Smith, Good morning. I wanted to ask you similar questions for Duke Progress.
Okay.
And I think this would appear in your supplemental exhibit for rebuttal, page 1. The amount of federal EDIT is 400 million, approximately.
Yes, it is.
The amount of North Carolina EDIT is 24 million.
Yes.
And the amount of deferred revenues, 122 million. Is that right?
Yes, it is.
And by comparison, would you agree with me that the amount that DEP proposes to increase base rates after the settlement with the public staff is 408.9 million a year?
I'm sorry, you broke up.
Oh,
Oh,
can
I'm
you hear
sorry.
me now?
I can, yes.
408.9 million per year for DEP?
Yes.
Okay. So as I understand it, Duke has put into effect a temporary rate increase pending the completion of the rate case. And in that temporary rate increase, the amount that customers' bills go up has been zeroed out for the time being by offsetting some of the tax money that Duke is returning to customers. Am I right?
That is correct.
And that's the same for both operating companies, correct?
Correct.
All right. But going forward, the proposal, instead of continuing to zero out a rate increase at this point, is to spread out the return of that money, as you mentioned earlier, over 5 years for the federal amount and over 2 years for the North Carolina amount and the deferred revenue amount, right?
Yes.
Okay. It was a little confusing to me, and this isn't your testimony, but I think I saw in the summaries from the public staff 1 year, but they've settled on 2 years according to the settlement agreement, right?
Correct.
Yeah, you can't speak to what they said, and it may have been my error. If I'd asked you to please turn to what was marked in our filings, Attorney General's Office Exhibit 7 for reference in these hearings. And that appears to be a return. You're there.
Yeah, I'm getting there. Just a minute.
Sure. And for your information, the top line of that says return of federal unprotected excess deferred income taxes. Do you see where I am?
I do.
Okay.
All right, Ms. Forrest, let's go ahead and mark the document, please.
Sure. I'd ask that this be marked AGO McManus Smith Cross Exhibit 1. I don't see the chairman now.
All right, the document shall be so marked, Ms. Force.
Okay, thank you. Now, I'll submit to you that this is a depiction of several recent orders from the Utilities Commission where the commission has addressed the time frame over which the EDIT and other tax items would be returned through a similar tax rider mechanism. Are you familiar with these other cases?
I am not.
Ms. Smith?
I'm sorry. No, I'm not.
Okay, we can go through. I have also provided in other exhibits, and I can ask you to turn to the correct pages of those exhibits then so that we can document this. Or if it's acceptable to do, we can make reference subject to check. Do you want me to go through each of those, Ms. Jagannathan?
I don't think we need to belabor it as long as, I don't know that they're familiar with the cases, but I think they're fine accepting things subject to check.
Okay, I will just, I'll go ahead and describe the way it appears on this, depiction then. Would you agree with me that the Tax Act that you referred to earlier, the Federal Tax Act, took effect January 1st, 2018?
Yes.
Yes.
And in the first line I have there on the graph shows Aqua. Are you familiar? There's an Aqua water utility in North Carolina that filed a rate case in which they agreed in an order that was issued December 18th, 2018. They agreed by settlement that their unprotected EDIT would be returned over a 3-year period. So that first bar that shows the return in that case relates to the 3-year period starting when the new rates took effect until they would be fully returned. Do you understand? You follow the logic in that?
I do.
In addition, the Aqua settlement provided that North Carolina EDIT would be returned over 3 years, starting at the same time as those rates took effect. And the deferral amount we've talked about in this case, they also had a deferral amount in that first year that was to be returned over a 1-year period. And that is not depicted on the graph, but I submit that that's the case. And there is, we can have the commission take judicial notice if you don't want to accept that subject to check.
I accept it.
Okay. The next. Okay, thank you. And the next case that's listed there is Carolina Water Service, another water utility in North Carolina. And they had a rate case that was decided on February 23rd, 2019. And in that case, the commission ordered that it was a litigated issue, and the commission ordered that the return of the unprotected EDIT be conducted over a 4-year period, beginning at the time that rates took effect after that order. And that's what's demonstrated in the second line of that graph. Do you accept that subject to check?
Yes.
The other items.
Of course, I'm gonna stop you for a minute. It appears that you're directing your questions at the panel, which is appropriate given that it's a panel, but we need to give each of the panelists an opportunity to respond so that we're not interfering with the court reporter's ability to transcribe their answers.
Thank you. And I think also one of the witnesses is for one of the cases and one is for the other. So I appreciate that. I'll try to be clear about that.
Okay.
As far as Aqua, I believe it was clear on the record. As far as for Carolina Water, Ms. McManus, would you accept that subject to check for the?
Yes. Yes, I do.
And Ms. Smith?
Yes, I do.
Just to follow up on that, in that same order for Carolina Water, the amount that was returned, as in the Aqua case, was returned over a 1-year period from the effective date of that order. But the North Carolina EDIT was not addressed because they'd had a previous order that addressed that amount. Would you agree to accept that subject to check, Ms. McManus?
Yes.
And Ms. Smith?
Yes.
The third company that's listed there is Piedmont Natural Gas. You see that that order doesn't have a docket number. For some reason, it's not filled in. That was G9 sub 743, which was a Piedmont general rate case decided October 31st, 2019 by the commission. And in that case, the company had agreed to return of the EDIT over a 5-year period. Do you see that, and would you agree with that subject to check? Ms. McMahon?
Yes, I do.
And the North Carolina EDIT was addressed in that case too, and it was to be returned over a 3-year period. And the return of the amount that was deferred, we've referred to it as the deferred amount, was returned to customers over a 1-year period. Do you agree to that, subject to check?
Yes.
Ms. McManus and Ms. Smith?
Yes.
Okay, thanks. Now, we're looking in this case, and that's the 4th case. That's not an order that's been decided yet, but the proposal, as I understand it, would begin to return the federal EDIT beginning when rates take effect in each of these cases. So sometime, I guess we're thinking before the end of 2020, and then returned over a 5-year period. Is that right? We've already talked about that.
Yes, it would be returned over a 5-year period for DEC.
So what we're talking about then on this graph, and we've already talked about the other two, I won't put that in again here, but what we're talking about then with each of these companies is that in the case of Aqua, they had the use of all of that money for a year, but everything will be returned to consumers by the end of 2021. Carolina Water, it's pushed back so that it's closer to 2023. Piedmont, 2024, and Duke is not going to be returning that money until 2025. Correct? You agree with me? That's
yes.
Now, the knowledge that this money would be returned to customers would have been something Duke would have been aware of at much earlier. Isn't that right?
Yes, that's correct.
So in fact, was this not, Ms. McManus, do you recall this was an issue in the last Duke rate case before the end of the hearing? Isn't that right? It was addressed
Yes.
in that case.
I do recall that it was the EDIT and the return to customers was definitely an issue in the last rate case. And the commission issued an order telling us what we should do with the EDIT, and we've complied with that order.
And the direction was to carry that, that would be resolved in a future rate case. Is that right?
Yes, it was. And I would also note that in the commission's order, they specifically noted that during this time period between then and when the amounts would be brought forward and addressed in a future rate case and return to customers, that customers would be held harmless of this fact, because EDIT is reducing rate base, it's reducing current rates. The company has use of the money, as you indicate on this chart, and customers are held harmless of the commission's decision to push this forward to a future rate case.
And so I believe what your position is then, that customers' money was not returned to them sooner, but during that time they had the benefit of it as a reduction to rate base, so that there was not a rate of return earned on that to that extent. It was an offset. Am I right?
That's right. Customers' rates are lower as a result of the funds that we hold being reflected in existing rates.
So if it weren't reflected in rates, they would be higher. But now we're talking about returning the money to customers over a period of years. This is a challenging time for ratepayers. Would you agree with me?
Yes, Ms. Force, I would note one thing you just said is that if we did not have these amounts reducing rate base the way we do, the commission would have ordered that we defer these amounts and accrue a return into that deferral. So in either case, the commission was taking into consideration that customers not be harmed during this delay.
And now the question is how soon the money will be returned to customers, either over the levelized 5-year period that's proposed for the EDIT, or some other method that will return it more quickly?
Yes, you are correct that in the previous rate case and in this rate case, the real question at hand is the time period over which we return amounts to customers. And in the testimony that we filed in the previous case, as well as this case, we give the commission our input on the factors that should be considered when making this kind of a decision.
Okay, thank you. So I think there's already been questions about the, give me 1 minute, please. As I understand it, in earlier questioning, Mr. Young told us that Duke does not expect to be a cash, he called it a cash taxpayer until 2027. This is, do you remember, were you here? Did you hear that testimony?
It's Mr. Newland.
I heard.
I'm sorry, Mr. Newland. You remember that?
I do.
Okay. The amount that is involved for customers then, if they're borrowing money in order to pay their bills, that would be often quite a bit higher percentage interest rate in order to pay this money to Duke. And would you agree with that?
I guess I don't know at what rate a customer would borrow money. I would point out that to return the funds to customers through the rebate mechanism, Duke Energy, the companies, DEC and DEP, have to borrow money to return the funds. We don't have a pile of cash sitting there. We have to borrow money to refund the EDIT.
Ms. Force, I would also note that when I spoke of the fact that these amounts are reducing rate base and that they benefit customer rates, that benefit is at the company's weighted average cost of capital.
Okay, thank you. I appreciate that. And that's a calculation that was made and adjusted to the number of years over which the proposal was made for 5 years, or the other two, or excuse me, 5 years for the federal and the 2 years for the state. Am I correct in that assumption?
You're correct that the format of the rider that is settled on with the public staff is a levelized rider, which does take into consideration the this return that is owed to customers, and it is would be at the weighted average cost of capital.
Okay, thank you. And if customers were to pay their credit card, pay their Duke bill using a credit card, the price of interest might be 18% or higher. Isn't that right?
I don't know.
Yeah, I'm not aware exactly what the
Going right.
interest is on credit cards if you run a balance.
Probably not 2.95%.
It's probably not.
I don't have any other questions. Thank you. Appreciate it.
Thank you, Ms. Force. Any additional cross-examination for the panel? Okay, hearing none. Any redirect for the panel?
Chair Mitchell, I just have a few questions.
Right.
And just to keep the record clear, I'll start with Ms. McManus and she can answer. And then if Ms. Smith has anything to add, she can go ahead and do that. So Ms. McManus, in response to Ms. Force, you talked about this a little bit, but can you just elaborate on how customers have benefited from the company having the use of EDIT over the last couple of years?
Yes, I can. And also, I think Witness Newland can probably speak to this as well. But we've talked previously about how deferred income taxes are a source of cash to the company. and, you know, they are an interest-free source of cash. And so when we collect monies in advance of paying to the IRS, then we are able to invest that money in our business and avoid the financing costs. And that is all reflected in the company's rates.
Ms. Smith or Ms. Newland, do you have anything to add?
No, I do not.
I have nothing else to add.
Okay, and Ms. McManus, would you agree that the commission needs to evaluate the appropriate flowback period for unprotected EDIT on a case-by-case basis?
Yes, the chart that Ms. Force walked through provided some information on a number of cases before the commission, but I would be cautious about considering the timing of the flowback of EDIT as being a one-size-fits-all or a cookie-cutter approach. And as a result, when we made our direct filing, we provided some information to be considered to address this issue, and that was the impact on credit metrics, and witness Newland had his testimony addressed that. And then we also spoke all of rate volatility, and those two items are really very dependent on the amount of EDIT that a company has, as well as the financial strength of the particular company. So I know nothing about those items for Aqua, Carolina Water, and I'm not familiar with the Piedmont amounts, but those things would all be taken into consideration, which in my mind means that you can't just assume that one amortization period is appropriate for all companies. So we've put that we've put in our testimony that the commission should give consideration to these things. However, we have agreed with the public staff on the periods that are reflected in our settlement, and would ask the commission to approve the settlement.
Thank you. And just one last clarifying question. I believe Ms. Force said that Duke won't be returning EDIT until 2025. If the settlement is approved, Duke would begin, both Duke Energy Carolinas and Duke Energy Progress would begin flowing back unprotected EDIT under the rider as soon as rates are effective in this case, correct?
That's right. And Ms. Force also mentioned interim rates. And so really EDIT is beginning to be returned to customers when interim rates are reflected in our to customers. And you are correct that the 2025 date would be the end of the return to customers, but not the beginning.
Thank you. I have nothing further.
Okay, at this point, we are going to take our morning break. We will go off the record. We will come back on at 11:30. Please mute your lines and turn off your video. Thank you. All right, it's 11:30. Let's go back on the record, please. Any questions from commissioners for the panel? Commissioner Brown-Bland?
Yes. Just one. So under the second settlement agreement with the public staff, if there's a future increase or some change in the federal tax rate, the bar charts that are seen on AGO McManus Smith Cross Exhibit 1, they could potentially change?
Yes, the settlement does have several provisions in it related to what the company would have the opportunity to propose if there were a change in tax rates during this flowback period. I don't have the settlement in front of me right now, so I'm not looking at the specific provisions, but there were provisions in the settlement to address what the company might be able to propose in that event.
So that specific bar for DEC, DEP could change if there was a change before the 5 years was completed. Is that right?
I think that's correct.
All right. Thank you.
Commissioner Gray?
No questions.
Commissioner Clodfelter?
Yes, thank you. Mr. Newline, I'm going to start this question with you because you're Duke corporate, but I invite either Ms. McManus or Ms. Smith to chime in if they know. My recollection is that sometime in 2017, or maybe it was 2018, that Duke, Florida resolved a pending proceeding before the Florida Commission in which they were permitted to and were directed to, and they agreed to, in effect, repurpose a portion of EDIT and use it to fund or defray accelerated depreciation costs associated with early retirement of coal plants. Is my memory correct on that?
I'm sorry, Commissioner Clodfelter, that may have predated my time as treasurer, so I'm not aware of that.
Is there someone who's going to be testifying that might know about that? Ms. Smith, Ms. McManus, do either of you?
I am not familiar with what was done in Florida, I'm sorry.
And I'm sorry, I'm not either.
Did I miss my chance with Mr. Young? Would he have been the right person to ask that question?
Yes, definitely. He would have the knowledge.
I'm sorry. I'm sorry. It was a EDIT related question, and so that's why I reserved it for this group.
Apologies.
But, let me think about how to get that information in another way. Well, let me ask more generically. If that turned out to be the case, how would that have been handled from an accounting standpoint? If what happened was the company were permitted to or directed to take part of the EDIT in its accounting and simply repurpose those funds to some other purpose, how would that have been accomplished from an accounting standpoint? Let's take it as a hypothetical exercise.
I think witness Smith or witness McManus may be better at the.
All right. I'll take my answer from whoever can give it. What would you do?
I don't
know. I'm sorry to tell you that I'm not the accounting witness in this case either. We do have accounting witnesses. Obviously, the EDIT is a regulatory liability on our books, and it gets drawn down over time as we return those funds. So if we would apply those funds to something else, then it would be netted against. But without knowing exactly what we would be applying it to, I'm not sure if I can tell you the accounting today.
Who should I direct my question to? Is there someone else on deck in the future to help me with that?
I would say witness David Doss, who will be on later on.
David Doss?
Yeah, he's our accounting witness.
Right. Let me ask the two of you, Ms. McManus and Ms. Smith, another question. And because I'm not an accountant, I don't really know this, where this goes at all. So we get to the point where Congress enacts a tax. Let's just stay with the federal tax law change in 2017-18. So we get to the point where Congress enacts the tax law change and we have an effective date. And so at that point in time, some of what you're carrying is ADIT, some of it becomes EDIT at that point. I'm not worried about the funds you collected after the effective date. I just want to focus on the funds that had accumulated as ADIT up to that point in time. Okay, are we clear? All right.
So,
okay. All right. So is it possible at all to reconstruct today over what period of time those funds were collected and paid in from customers? Can you reconstruct the build up of the ADIT over time?
let me see if I understand your question. So we're saying that at the point that the tax law changes, so it was at 35%, changes January 1, 2018 to 21%. We have a balance of ADIT on our books, and we said we needed to remeasure it to know how much is now excess EDIT. But you're asking, can we somehow figure out how the construct of that ADIT balance, like over what years? My short answer is I don't know for sure, but certainly, I mean, these are deferred taxes. And so, you know, there are accounting entries that are being made every year that says, what is our book tax income? What is our taxable income? What are the differences computing the deferred taxes? Now, you know, these are very long-lived assets that create deferred taxes. And I guess I'm thinking also about the tax life is shorter. So I would think that potentially you could deconstruct this, but I'm not positive.
Well, one thing we would know for sure is that that represented funds that had been collected from customers prior to the effective date of the Tax Act. We know at least that much. Had been collected in rates as they existed and as customers paid under those rates prior to the effective date. We know that much.
Yes.
Right. But
yes.
I was just trying to get some sense of, do we know whether it was an amount that was collected over a period of 1 year, 3 years, 5 years, 10 years, order of magnitude, 15 or 20 years? We don't really know that, or can we know that?
I'm not sure how difficult it would be to do, but you're right that we, you know, these calculations are looking at the difference between a book life and a tax life. And for some of our assets, the book life could be, you know, 40 years. The tax lives are generally shorter. I'm familiar with some of them. I think that some of the tax lives can be as long as 20, some 15, some much shorter, like 7 and 5. So I think those are the kinds of time frames that we're talking about.
Okay. I'm not asking for that exercise to be done. I just wanted to know if it was doable, and understand I'm not asking that it be done, but I just was curious. And thank you for that. And I'll figure out what I want to know about the Florida settlement some other way. Thank you. That's all I have.
Commissioner Duffley?
I do not have any questions.
Okay. Commissioner Hughes?
No questions at this time.
And Commissioner McKissick?
No questions at this time.
Okay. Any questions on the commission's questions?
Chair Mitchell, if none of the interveners have a question, I just have one quick comment in response to Commissioner Clodfelter's questions.
Okay, let me just confirm. I'm hearing no questions on commission's questions. All right, you may proceed.
Thank you. Commissioner Clodfelter, we will certainly have someone ready to answer your questions about Florida, and Stephen DeMay would also be a good person to ask.
Thank you. That's helpful. I'll make a note of that. Thank you.
Okay, at this point, I will entertain motions.
Chair Mitchell, I would move that Ms. McManus's pre-filed exhibits be admitted into evidence in the Duke Energy Carolinas rate case dockets as pre-marked at the appropriate time.
Hearing no objection, your motion will be allowed.
And I would also move that Ms. Smith's pre-filed exhibits be admitted into evidence in the Duke Energy Progress rate case dockets at the appropriate time.
Hearing no objection, that motion will be allowed as well.
Thank you.
Madam Chairman, I would move that AGO McManus Smith Cross Exhibit 1 be admitted into the records for the Duke Carolinas and the Duke Progress case at the appropriate time.
All right, hearing no objection, Ms. Force, your motion is allowed.
Thank you.
All right, at this time, the witnesses may step down.
Thank you, Chair Mitchell.
Chair Mitchell, this is Kiran Mehta, and
yes, Mr.
Mr. Newland, I think, has completed his assignments for the consolidated portion of these hearings, as well as he has no assignments in the Duke Energy Carolinas and Duke Energy Progress specific portions of these hearings, and we would ask that he be excused entirely from the remainder of these hearings, if that is acceptable.
All right, I am not hearing any objections, Mr. Mehta, and with that, Mr. Newland, you may be dismissed. You are dismissed. Thank you very much.
Thank you, Chair Mitchell.
All right, it looks like at this point we will turn to the public staff. Public staff, you may call your panel.
Good morning. The public staff calls Michelle Boswell, Sean Dorgan, and John Hinton as a panel to testify on excess deferred income taxes.
All right, good morning. Let's go ahead and get you all under oath. Raise your right hands, please. Do you affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Yes. I do.
Thank you. All right, Ms. Holt, you may proceed.
I'll begin with Ms. Boswell. Please state your name, business address, and position for the record.
Michelle Boswell. I'm the accounting manager of the electric section of the accounting division of the public staff. My business address is 430 North Salisbury Street, Raleigh, North Carolina.
Ms. Boswell, on February 19, 2020, did you cause to be pre-filed in the Duke Energy Carolinas or DEC rate case, docket number E7 sub 1214, direct testimony and question and answer form consisting of 37 pages, 1 appendix, and 2 exhibits marked Boswell Exhibits 1 through 2?
I did.
Do you have any changes or corrections to your pre-filed direct testimony?
I do not.
Do you have any changes or corrections to the exhibits to your direct testimony?
I do not.
If I were to ask you those same questions today, would your answers be the same?
They would.
On March 25th, 2020, did you pre-file supplemental and settlement testimony in the DEC proceeding consisting of 12 pages and 3 exhibits marked as Boswell Supplemental and Stipulation Exhibits 1 through 3?
I did.
Do you have any changes or corrections to your supplemental and settlement testimony?
I do not.
If I were to ask you those same questions today, would your answers be the same?
They would.
Do you have any changes or corrections to the exhibits to your supplemental and settlement testimony?
I do not.
And on July 31st, 2020, did you pre-file testimony in support of a second partial settlement consisting of 5 pages?
I did.
Do you have any changes or corrections to your pre-filed second partial settlement testimony?
I do not.
If I were to ask you those same questions, would your answers be the same?
They would.
Chair Mitchell, I move that Ms. Boswell's pre-filed direct testimony, supplemental and settlement testimony, and second partial settlement testimony be entered into the record in this proceeding and copied into the record as if given orally from the stand in the DEC rate case dockets at the appropriate time. And that Ms. Boswell's appendix and exhibits attached to her pre-filed direct testimony be identified as pre-marked, and that Ms. Boswell's supplemental and settlement exhibits attached to her supplemental and settlement testimony be identified as pre-marked.
All right, Ms. Holt, hearing no objection, your motion will be allowed.
Ms. Boswell, is the purpose of your appearance here today to address portions of your direct testimony that relate to excess deferred income taxes, or EDIT?
It is.
Thank you. I'll move now to Mr. Dorgan. Mr. Dorgan, please state your name, business address, and position for the record.
Yes, Sean Dorgan. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm a staff accountant with the Accounting Division, Public Staff.
And on April 13th, 2020, did you cause to be pre-filed in the Duke Energy Progress rate case, docket number E2 sub 1219, testimony in question and answer form consisting of 44 pages, 1 appendix, and 3 exhibits?
I did.
Do you have any changes or corrections to your testimony?
I do not.
If I were to ask you the same question today, would your answers be the same?
They would.
Do you have any changes or corrections to the exhibits to your direct testimony?
I do not.
On April 23rd, 2020, did you pre-file supplemental testimony consisting of 11 pages and 3 exhibits identified as Dorgan Supplemental Exhibits 1 through 3?
I did.
Do you have any changes or corrections to your pre-filed testimony?
I do not.
Your pre-filed supplemental testimony.
I do not.
If I were to ask you those same questions today, would your answers be the same?
They would.
Do you have any changes or corrections to the exhibits to your supplemental testimony?
I do not.
Chair Mitchell, I move that Mr. Dorgan's pre-filed direct testimony and appendix and supplemental testimony be entered into the record in this proceeding and copied into the record as if given orally from the stand in the Duke Energy Progress rate case dockets at the appropriate time. And that Mr. Dorgan's exhibits attached to his pre-filed direct testimony and supplemental testimonies be identified as pre-marked.
Hearing no objection, Ms. Holt, your motion will be allowed.
Mr. Dorgan, is the purpose of your testimony today to address portions of your direct testimony that relate to excess deferred income taxes?
Yes, that is correct.
Now, is your testimony on EDIT any different from that of Ms. Boswell's EDIT testimony that was filed in the DEC rate case?
It is not.
Mr. Dorgan, do you have a summary of Ms. Boswell and your EDIT testimonies?
I do.
Could you please read that into the record?
I'd be happy to. The purpose of our testimonies is to address the public staff's recommendation regarding the impacts of the reduction of federal income taxes due to the Federal Tax Cuts and Jobs Act, as well as the impacts of the reduction of state income taxes due to the state of North Carolina's recent tax decrease. In our testimonies, we recommended several adjustments relating to the reduction of federal taxes due to the Federal Tax Cuts and Jobs Act. First, we made an adjustment to include the return of protected federal excess deferred income taxes, or EDIT, based upon the company's calculation of the net remaining life of timing differences. These deferred taxes are deemed protected because the Internal Revenue Service does not permit regulators to flow back the excess to ratepayers immediately, but instead requires that the excess be flowed back to ratepayers ratably over the life of the timing differences that gave rise to the excess. Second, for unprotected federal EDIT, which are excess deferred taxes that result from all other timing differences, and which can be flowed back to ratepayers however quickly the regulators deem reasonable, we recommended that the EDIT regulatory liability associated with the unprotected differences be removed from rate base and placed in a rider to be refunded to ratepayers over 5 years on a levelized basis with carrying costs. Third, for deferred revenue owed to customers resulting from the difference in rates for that period of time between enactment of the Federal Tax Cuts and Jobs Act and the federal tax rate decrease, the time that that became effective, and the time that the tax rate was actually reduced in the calculation of ratepayers' rates, we recommended that the regulatory liability associated with the deferred revenue be removed from rate base and placed in a rider to be refunded to ratepayers over a 1-year period of time on a levelized basis with carrying costs. Finally, for state EDIT, we similarly recommended that the state EDIT regulatory liability associated with the reduction of North Carolina's state income tax rates be removed from rate base and placed in a rider to be refunded to ratepayers over a 1-year period of time on a levelized basis with carrying costs. And as already been discussed in the company's summary, and as will be discussed later in the unconsolidated portion of this hearing, the companies and the public staff have entered into a second agreement and stipulation of partial settlement. It includes proposed treatments for federal protected EDIT, federal unprotected EDIT, deferred revenue, and state EDIT. This concludes the public staff summary.
Thank you, Mr. Dorgan. And Mr. Grantmeyer will be handling Mr. Hinton's.
Chair Mitchell, this is William Grantmeyer. I'm sponsoring John Hinton on this panel. He pre-filed his testimony under the financial section that we did earlier, and he has no additional written testimony filed for today. Thank you.
All right, thank you, Mr. Grantmeyer and Ms. Holt.
Our witnesses are available for cross.
All right, Ms. Force, you may proceed.
Thank you, Chair Mitchell. Good morning. I have questions from Ms. Boswell. Sorry, I had you pinned there. You've testified about EDIT and the return of money in prior proceedings for the public staff, and I've asked you questions in prior proceedings. Do you recall that?
I do.
In the Carolina Water Service case, I asked you questions. I'm referring to that, but they were questions that related back to the Duke proceeding in the last rate case. And my question for you in that Carolina Water Service case, I can refresh your memory with the transcript if you like, but I bet you remember. One of the things that I asked you was whether initially in the prior Duke rate case, that's 1146, your testimony and recommendation was that Duke return the money, the federal EDIT to customers over a 2-year period. And later you supplemented your testimony and indicated a 5-year period, and that there was a range in between then that might be adopted. Is that a good representation of your testimony in the last Duke case?
It is.
Okay, thank you. That made it short. I want to clarify something that I misunderstood when I read your summary for the case for the public staff witnesses. In the as I understand the settlement, it's close to what you proposed from the standpoint that there would be a 5-year period for levelized return of the federal edit money to ratepayers. And then the period for return of the state edit would be 2 years, not 1. Am I right?
That is correct. Since Mr. Dorgan did not file for the settlement, we did not include that in our joint summary.
Understood. But that's the case for both companies. Is that right, Mr. Dorgan?
That is correct.
Okay. And similarly, as far as the money that's been referred to as the deferred money that's being returned to customers, that's going to go over a 2-year period as well instead of a 1 year as initially proposed?
That is correct.
By the public staff? Okay, thank you. And we had some questions from commissioners directed to the company witnesses. Were you listening at that time?
I was.
Commissioner Brown Bland asked about some conditions that apply to this settlement with Duke that would possibly result in adjustment of the return of the EDIT to customers. Is there you would agree with me that there's such a condition in this settlement agreement that you're proposing with Duke?
There is.
And was that similar condition also applied in the Aqua case that is referred to on that? Have you seen that schedule that we used in cross-examination with the other witnesses? At any rate.
You're referring to your cross exhibit 1?
Yes.
Yes.
That's the one that was distributed early. And so in the Aqua case, did you have a similar condition?
We did not.
There was not a similar condition. And how about Carolina Water?
Carolina Water was a litigated case, so there was not a settlement within the confines of that case.
Oh, that's right. And that sort of a condition was not then applied by the commission either then. Am I right? And how about in the Piedmont case? Was that condition found in that settlement?
I was not involved in the Piedmont rate case, so I can't speak to if it was or was not.
And would you know, Mr. Dorgan?
I was not involved in the Piedmont case either, so I would not know whether that particular provision was included in the Piedmont settlement either.
Okay. So as far as you know, you don't know one way or the other, is my understanding for both of you.
Mm-hmm.
So there was also a question from Commissioner Clodfelter that was about, and I don't want to speak for him, but I believe it was perhaps using the money that's agreed to be returned to customers in a different, possibly in a different way. Are you aware of another docket in which the commission looked at the issue of the response to the change in taxes and docket number M100 sub 148?
I am familiar with the docket, yes.
And are you familiar with that there is a separate commission order on how to address the tax, the return of tax money to customers in that case?
The order laid out at what point in time the companies needed to come in to file their proposal to return said monies.
Okay, that's fair. I don't have any other questions. Thank you very much.
All right, any additional cross-examination for this panel? All right, hearing none, any redirect for the panel?
Yes, Chair Mitchell, I just have one clarifying question for Ms. Boswell. Ms. Boswell, the condition with regard to EDIT to which Ms. Force referred to, was that included in your initial pre-filed direct testimony?
It was not.
Thank you. That was part of the settlement, was it not?
It was.
Thank you. No further redirect.
Okay, questions from the commissioners. Commissioner Brown Bland.
No questions.
All right, Commissioner Gray.
No questions.
Commissioner Clodfelter.
Nothing.
Commissioner Duffley.
No questions.
Commissioner Hughes.
No questions.
All right, and Commissioner McKissick?
No questions.
All right, at this point, I will entertain motions.
I move the admission of Ms. Boswell's appendix and exhibits to her direct testimony in the DEC rate case at the appropriate time, or supplemental and stipulation exhibits 1 through 3 in the DEC rate cases at the appropriate time. I also move the admission of Mr. Dorgan's exhibits, 3 exhibits as identified. I move them in for admission in the DEP rate case at the appropriate time, and also move the exhibits to his supplemental testimony in the DEP rate case at the appropriate time.
All right, hearing no objections to your motion, Ms. Holt, it will be allowed. All right, with that, I believe the witnesses may step down, and I believe we can dismiss them for the remainder of this hearing. All right. I think with that.
Sorry, this Margaret Forth for the Attorney General. Just to clarify, I don't remember whether we asked yesterday to dismiss Mr. Baudino from the remainder of the hearings. He was only testifying in the consolidated proceeding, and we'd ask that now.
All right. Any objections to Ms. Force's motion to dismiss, that Mr. Baudino be dismissed at this point in time? All right, hearing none, Ms. Force, your motion is granted. He may be dismissed.
Thank you.
All right, at this point in time, I believe we will now proceed to discussion of matters related to the grid improvement plan. We are now with Duke. Duke, you may call your witness.
Thank you, Chair Mitchell. This is Jim Jeffries on behalf of Duke Energy Carolinas and Duke Energy Progress, and we would call Mr. Jay Oliver.
All right, Mr. Oliver, let's go ahead and get you under oath. Raise your right hand, please. You affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. You may proceed, Mr. Jeffries.
Thank you, Chair Mitchell. Mr. Oliver, could you state your name and business address for the record, please?
Yes, my name is J. William Oliver, and my business address is 400 South Tryon Street, Suite 27E, Charlotte, North Carolina, 28202.
Thank you. Mr. Oliver, where do you work?
I work for Duke Energy Business Services.
And what's your position with Duke Energy Business Services?
My title is General Manager, Grid Strategy and Asset Management Governance.
All right, thank you. Mr. Oliver, it's true that you caused to be filed in the DEC docket, that's docket number E7 sub 1214 on September 30, 2019, direct testimony consisting of 55 pages, as well as Oliver direct exhibits 1 through 18, correct?
Correct.
And that direct testimony and exhibits and those exhibits were subsequently corrected by revised testimony exhibits filed in docket number E7 sub 1214 on October 23rd, 2019. Is that also correct?
Yes.
All right. Do you have any changes or corrections to your corrected direct testimony or corrected Oliver direct exhibits 1 through 18?
Yes, I do have one change. My title has changed since we filed the direct testimony. At the time, it was General Manager, Grid Solutions, Engineering and Technology. My title is now General Manager, Grid Strategy and Asset Management Governance.
Thank you. With that correction, if I ask you the same questions that are set forth in your corrected pre-filed direct testimony while you were under oath today, would your answers be the same?
Yes, they would.
All right. And Mr. Oliver, you also caused to be pre-filed in the DEC docket rebuttal testimony on March 2020, consisting of 62 pages and Oliver Rebuttal Exhibit 1. Is that correct?
Yes, it is.
Do you have any changes or corrections to your pre-filed rebuttal testimony or exhibit?
I do not.
And again, if I ask you the same questions that are set forth in your pre-filed rebuttal testimony today while you were on the stand, would your answers be the same?
They would.
And finally, you are the same J. Oliver that caused to be filed along with Ms. Jane McManus, joint testimony of J. Oliver, Jane McManus in docket number E7 sub 1214 on August 5th, 2020, consisting of 17 pages and GIP exhibits 1 through 3. Is that correct?
That is correct.
All right. And again, do you have any changes or corrections to your pre-filed joint testimony?
I do not.
And if I ask you the same questions set forth in your pre-filed joint testimony while you're under oath today, would your answers be the same?
They would.
Thank you. Chair Mitchell, we would move that Mr. Oliver's pre-filed direct testimony, corrected direct testimony, rebuttal testimony, and the joint testimony of Ms. McManus and Mr. Oliver, as described above, be entered into the record in the DEC rate case as if given orally from the stand, and at the appropriate time copied into the record in docket number E7 sub 1214, and that the exhibits attached to Mr. Oliver's pre-filed testimonies in the DEC case be identified as pre-marked.
All right, hearing no objection to your motion, Mr. Jeffries, it will be allowed.
Thank you, Chair Mitchell. Mr. Oliver, we now have to go through the same drill with the DEP testimony. So you're the same J. Oliver that caused to be filed direct testimony in docket number E2 sub 1219 on October 30th, 2019, consisting of 51 pages and Oliver direct exhibits 1 through 18, correct?
That is correct.
And do you have any changes or corrections to your pre-filed direct testimony?
I do not. I do not.
Okay. Any changes to your pre-filed direct exhibits?
No changes.
If I ask you the same questions set forth in your pre-filed direct testimony while you're under oath today, would your answers be the same?
They would.
You're also the same J. Oliver that pre-filed rebuttal testimony in docket number E2 sub 1219 on May 4, 2020, consisting of 62 pages and Oliver rebuttal exhibit 1, correct?
Yes.
And do you have any changes or corrections to your pre-filed rebuttal testimony or Oliver exhibit 1, rebuttal exhibit 1?
I do not.
And if I ask you the same question set forth in your pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
Thank you. And finally, you are the same J. Oliver that caused to be filed joint testimony on August 5th, 2020 with Ms. Jane McManus in docket number E2 sub 1219, 17 pages and GIP exhibits 1 through 3, correct?
Correct.
And do you have any changes or corrections to that joint testimony?
I do not.
And finally, if I ask you the same question set forth in your joint testimony while you're under oath today, would your answers be the same?
They would.
All right, thank you. Chair Mitchell, we would move that Mr. Oliver's pre-filed direct testimony, pre-filed rebuttal testimony, and pre-filed joint testimony with Ms. McManus in the DEP rate case be entered into the record as if given orally from the stand and copied into the record in docket number E2 sub 1219 at an appropriate time, and that the exhibits attached to Mr. Oliver's pre-filed testimonies in the DEP case be identified as marked.
All right, Mr. Jeffries, there being no objection to your motion, it will be allowed.
Thank you, Madam Chair. Mr. Oliver, have you prepared a summary of your direct testimonies?
I have.
Could you provide that to the commission, please?
Certainly. My name is Jay Oliver, and I am employed by Duke Energy Business Services, LLC, DEBS, as General Manager, Grid Strategy and Asset Management Governance. My duties and responsibilities include planning for grid upgrades, system planning, and overall distribution asset management strategy across Duke Energy, including Duke Energy Carolinas and Duke Energy Progress. My testimony in these dockets supports 1, the operation and performance of DEC and DEP's transmission and distribution T&D systems, and 2, the operational and engineering aspects of the grid improvement plan proposed for both DEC and DEP's North Carolina transmission and distribution systems. The company has worked hard to maintain the T&D system and reliably meet the needs of its North Carolina customers, and overall the grid is reliable and well maintained. With more than 3,300 megawatts of solar, our North Carolina T&D system ranks second in the nation in terms of utility scale solar connections. But we also understand more must be done to improve the state's energy infrastructure to meet the energy challenges and opportunities that lie ahead. Our GIP proposal in these cases are the product of directions from the Commission to undertake a collaborative process with interested parties to explore grid improvement. This direction was provided by the Commission order in DEC and DEP's last base rate adjustment proceedings in North Carolina. This process started with an assessment of what drivers were pushing our existing grid toward insufficiency, which are the 7 megatrends I identify in my testimony. From there, we conducted a series of meetings with stakeholders and other interested parties to seek input on the megatrends and our ideas about how to address them. Finally, based upon the Commission's feedback from our prior cases, the 7 megatrends, and feedback from the parties that participated in our stakeholder process, we put together the package of grid improvement plan programs contained in my testimony. The GIP is a carefully targeted set of programs designed to improve, modernize, and protect our T&D systems in North Carolina for both DEC and DEP. This 3-year, approximately $2.3 billion program is designed to substantially improve the functionality, flexibility, and responsiveness of the electric grid, supporting approximately 3.4 million North Carolina customers. It will do this by responding to greater demands being placed upon our transmission and distribution infrastructure by physical and cyber threats, demand for greater utilization of renewables and distributed energy resources, stronger and more frequent storms, increased use of smart grid and smart meter technology, more concentrated population growth, and rising customer service expectations. The GIP is a complete plan unto itself and will produce sustainable and demonstrable benefits for our customers, including enhanced system reliability and distributed energy resource enablement that will effectively pay for the costs of implementing the plan over time. It is also distinct and separate from normal ongoing CapEx and O&M spending engaged in by DEC and DEP to maintain their respective abilities to provide safe and reliable electric service to their customers. As the culmination of the GIP stakeholder process initiated by the Commission at the end of our last base rate cases, we have now concluded settlement agreements with most parties who took a position on our GIP proposals. These parties include commercial and industrial customers, the commercial group, SIGFR and Harris Teeter, environmental and social justice parties, North Carolina Sustainable Energy Association, North Carolina Justice Center, North Carolina Housing Coalition, Southern Alliance for Clean Energy, National Resources Defense Council, and Vote Solar, and representatives of the using and consuming public, the public staff. The results of these settlements is an agreement by the majority of parties to the rate case dockets to support deferred asset treatment for roughly $1.3 billion in specified grid improvement plan programs, and an agreement by the company to withdraw its request for deferral treatment of the remaining $1 billion in remaining GIP programs. The company supports this resolution of its GIP requests in these proceedings and asks the Commission to approve the settlements presented to the Commission in this regard.
Thank you, Mr. Oliver. Chair Mitchell, Mr. Oliver is available for cross-examination and questions by the Commission.
All right, thank you, Mr. Jeffries. I believe the public staff is up. Ms. Cummings, you're on mute. I believe you were.
The public staff has no questions for Mr. Oliver.
All right, Ms. Force. All right, Ms. Force, you are on mute as well.
Sorry, my space bar didn't work that time. No questions from the Attorney General either.
Okay. Mr. Page.
Thank you, Madam Chairman. Mr. Oliver, my name is Bob Page. I represent the Carolina Utility Customers Association, a group of large industrial and manufacturing customers. How are you today?
I am doing well, and I hope you are too.
My client is one of the ones who did not enter into a settlement agreement with Duke on the grid modification. Is that correct?
I believe that's the case, yes.
All right, I have heard the program that you're testifying about this morning. A large different number of names have been ascribed to it, including grid modernization, grid modification, grid improvement plan. Which terminology do you prefer?
I prefer grid improvement plan or GIP.
All right. Why don't we just use GIP to make it a little bit shorter? Can you give me the amounts of GIP investments for both Duke Carolinas and Duke Progress, and then cumulatively, that Duke is seeking to place in these cases into a segregated account for collection in subsequent rate case or cases?
I believe I can. If you're, make sure I understand the question correct, it would be the amount that we're asking for deferral accounting treatment in both DEC and DEP.
That is correct.
I can do that. I'll have to take a look at one of my books here. I'm going to have someone look that up for me and bring that over, but in the meantime.
Would you accept, subject to check, that for the two companies together, the amounts of about 1.3 billion?
Yes, it's about 1.25 billion and approximately 800 million in DEC and approximately 400 million in DEP, but we'll certainly get those exact numbers.
All right, and that'll be fine. You can interject with those anytime that you get them. In the current cases, isn't it true that there is a modest amount of money, perhaps in the neighborhood of $20 million, that will, because of the timing of it, seep into the accounting for this case and be absorbed into whatever rates are ultimately set by the commission in these two cases?
I believe that's true, yes.
All right. The numbers that we've just described, the approximately 1.3 billion to go into the accounting reserve and the current amount, a modest amount, whatever that is, 20 million or so, is that all of the spending that Duke proposes in the GIP program over the next decade?
The GIP program is a 3-year program, and that is what we're talking about here today. I can't talk about what we're going to propose over the next decade. What I can say is,
why can't you talk about that?
Because we have not had an opportunity to work with our stakeholders yet to come up with a collaborative plan like the plan we're talking about today. We've signed settlement agreements with a very diverse group of stakeholders that represent low-income customers, they represent commercial industrial customers, they represent environmental groups, and before we would bring another package like that in front of this commission, we need to work with those stakeholders in a similar way that we did for this 3-year plan. So no,
isn't it a fact, as Duke has previously announced on several occasions, that your plans for grid improvement spending over the next decade for both Duke Carolina and Duke Progress in the state of North Carolina are in the approximate range of $10 billion?
I certainly would say I'm not all that familiar with those numbers, but I certainly would
Well,
say
it's your,
that-
I'm astonished to hear you say that, sir, because this is your area, isn't it?
It is
If
my-
anyone's going to be familiar with it, wouldn't you be familiar with it?
All right, I'm gonna interrupt. Mr. Page, please let the witness complete his sentence before asking your next question in the interest of allowing our court reporter to transcribe the proceeding. Thank you.
My apologies.
Mr. Page, I am very familiar with our grid improvement plans. It's a big part of my job in every jurisdiction that Duke Energy serves. We have a 3-year plan. That is the plan I'm familiar with. It is the plan that we are proposing today. I agree, grid investment is needed beyond this 3-year plan. It is part of what's necessary to transform the grid into where it needs to be in the future. Now that grid needs to go from a one-way grid where the wires get smaller as you go towards the customers to a two-way grid. To fully leverage distributed energy resources to their best use, two-way power flow model is needed. That is going to take some time and it will take some investment. But as far as the total amount of money that's going to take to specifically address those issues, that's not something that I specifically have looked at. And again, as we go down that path, we will work with the stakeholders in the states that we serve, particularly North Carolina, and try and reach agreements just like we reach here today.
Are you saying then that after the recovery of all of the dollars that Duke is seeking to put in a separate deferred accounting treatment today, and the current amount that's included in these two rate cases, which is nominal, as we have discussed, are you saying that is going to be all of the GIP spending over the next decade?
I'm not saying that. I'm saying that we need to work with our stakeholders to determine what the appropriate level would be going forward. I don't know what things are going to look like in 3 years. I do know what they look like now. I do know what we need to do to start preparing the grid for the future. We have the right plan for that. It may be that 3 years from now, we propose a plan that looks similar. But again, that's something we would do at that time, bring it to the commission at that time, and they would rule appropriately with their judgment at that time.
Do you know whether or not your employer has previously presented to the commission testimonial indications that it plans to spend in North Carolina over the next decade the sum of $10 billion or approximately that amount? Do you agree or disagree that your company has made such statements?
I believe you're referring to a plan that was proposed in the last base rate case proceedings, plan called Power Forward. And that plan is no longer in place. We are not proposing a Power Forward type plan. In fact,
so is your,
totally
I'm
different.
sorry, I didn't mean to interrupt. Please finish your answer.
Well, that's okay, sir. We're not proposing that plan. We haven't proposed that plan in this particular case. What we're proposing is separate and distinct from that plan, specifically designed to deal with the mega trends affecting our state, specifically designed to allow us to truly leverage the growth in distributed energy resources, particularly private distributed energy resources, to effectively serve the growth in electric vehicles in our state, to effectively battle cyber attacks on our system, to effectively help the company achieve its carbon reduction goals. That is what this plan is about. I'm not, it's just not that related to the plan that you're talking about, sir.
So it is your testimony that the GIP plan is not simply Power Forward in a different suit of clothes?
The GI plan is not Power Forward in a different suit of clothes.
All right. Are you familiar with statements that Ms. Lynn Good, who is the president of Duke Energy, the overall boss, she succeeded Mr. Rogers, that she has said to groups of the Wall Street investors that Duke intends to use this program, grid modification, grid improvement, GIP, to drive its earnings over the next 10 years. Are you familiar with that?
Objection, Chair Mitchell. Unless Mr. Page can show Mr. Oliver a document with that statement. I don't think Mr. Oliver's obligated to accept Mr. Page's paraphrasing of what Ms. Good said.
Will he accept it subject to check? I'm sorry I didn't identify this as a cross-examination exhibit. I didn't realize it would be controversial.
All right, Mr. Page, can you identify with more specificity where those remarks that you referred to are coming from so that the witness take that information into consideration?
I will be happy to submit a written source of this as a late filed exhibit if that is acceptable with the commission.
And Chair Mitchell, if I may clarify, I'm not trying to make Mr. Page's life difficult here, but he characterized Ms. Good's statements as indicating what the company intends to spend under this program, which I took to mean the grid improvement program. And I don't believe that's what Ms. Good said. And that's why I was asking that the witness be provided a statement of what she actually said and what, instead of what Mr. Page says she said.
I'm happy to provide the statement that I'm relying on. Again, I had no idea that this would be controversial.
All right, Mr. Page, I will allow the question to proceed. You will provide the document that you are looking at as a late filed exhibit. And please restate your question with as much specificity as you can provide at this point so that the witness may consider that information when he is answering the question.
Well, Madam Chairman, the purpose of my question was to elicit the extent to which the witness was familiar with the statement, and he has said he's apparently not familiar with it. So I don't need to ask him anything else about his familiarity with it. I'll just furnish the document and let it speak for itself.
All right, Mr. Page, please furnish the document and proceed with your next question.
Thank you, Madam Chair. Mr. Oliver, would I be correct in stating that of the dollar amounts that you and I have talked about, the $1.5 billion approximately that's to go into the deferred account and be recovered in a subsequent rate case, if Duke is granted authority by the commission to spend and recover these dollars, some of that money will go, will it not, into providing modalities and functionalities and processes that will allow Duke's grid to do things which today it cannot do. Am I correct in that statement?
You are correct.
And these would include certain things like smart meter functions, smart grid functions, self-diagnosing grid software, self-healing grid arrangements, and real-time information for both the company and its customers. Are those some of the new functionalities?
Not smart meter functions. The grid improvement plan is not the smart meter installation program is not part of that. But the rest of what you described are certainly part of the functionality that we will get when we implement the grid improvement plan.
All right. Are some of the other things that you would get what I would refer to as more normal routine grid improvement asset investments of the kind Duke has been making for probably at least the last 100 years, things like beefed up lines, new lines, poles, transformers, that sort of thing?
Generally, no. Perhaps as we are providing two-way power flow, we will be upgrading the current carrying capability of those distribution circuits to the standard required for two-way power flow. But that would be one of the only things that would fit that description in the current grid improvement plan.
Yeah, I'm trying to get a sense here of the balance or the ratios between what I would call the new bells and whistles that come along with the GIP program and well, there was never a term like plain old telephone service or POTS like we had in the telephone industry. I'm not aware of anything similar to that in the electric power industry, but if you see the point I'm getting at, can you give me such a ratio between the new bells and whistles and the POTS as an electric function?
Well, I would say that something similar to POTS, plain old telephone service, which is certainly very important for our customers, is laid out in my Exhibit 1. Exhibit 1, we talk about providing load service for our customers, maintaining our reliability at the levels that is at today, maintaining our assets at the levels they are at today, providing safe and reliable electric service safety programs and environmental compliance programs. That would be, I guess, analogous to plain old telephone service. That, of course, is very important. When you take a look at what we've got in the grid improvement plan, and I do have a summary of that from one of the settlement agreements. I'll give you an example of a program that's a very important program, integrated volt bar control. Now, integrated volt bar control is a program in the grid improvement plan, and specifically in the DEC jurisdiction. It's going to allow us to lower voltage across a broad spectrum of customers, balance that voltage, which leads to less usage, leads to less fuel usage and benefits for our customers. That's not a program that we have today. It's not a part of plain old telephone service, for lack of a better term. Integrating the advanced distribution planning tools that is part of our ISOP program, which is that piece is in the grid improvement plan. Certainly not part of the plain old telephone service, as you put it, or let's call it Exhibit 1 to get more appropriate. In our self-optimizing grid program, about half of that is dedicated to new functionality associated with switching technologies and automation technologies that allow us to wirelessly control the grid based on instances and data that comes across the grid. Now, that's extremely important for the future as we move into the two-way power flow model. So I would say the majority of what we've got in the GIP is not bells and whistles, and that's by design. As we worked with our stakeholders throughout this process, we took a lot of input from the stakeholders. In the original GIP, we did have some programs that were a little bit more as you described. However, throughout that process and reaching agreement, we pulled some of those out, understanding that we wanted to best match what was the most important for our stakeholders, and I believe that's what we did.
All right, if I understood the portion of your previous answer that went directly to the question that I asked, you're saying a majority of the GIP spending will not be for new bells and whistles, but will be for the equivalent of POTS. Is that correct?
No, the opposite is the case. The $1.25 billion that we have in the deferral agreement, the vast majority of that, in fact, all of it, provides new technology that is required to move the grid to deal with what is coming in the future, to deal with the growth in private renewables, to deal with the growth in solar that we're experiencing, to deal with the growth in electric vehicles that we're seeing. So no, the vast majority of that would be, as you put it, sir, new bells and whistles. Now, there is part of self-optimizing grid where we enable two-way power flow, where we will be installing larger wire so we can actually have greater capacity for two-way power flow. That's very specific. The rules around what that looks like are very specific when it comes to self-optimizing grid functionality. That's the only thing in the program that would come close to what you described. Don't have the exact numbers in front of me, but that might be 25 to 30% of the 1.25 billion. And I would say it's among the most critical of the 1.25 billion, because that is truly the important piece around being able to distribute energy across the distribution grid instead of just downhill like we do it today.
Would you agree that one of the primary purposes, if not the primary purpose, behind the proposed GIP investments is to make Duke's grid functioning more reliable? That is, stated another way, to reduce the current level of outage times?
No, I would not agree with that. when we built this plan, we built it to address the 7 megatrends. The megatrends are pretty much undisputed in this case. I'll list a few of those megatrends. The first one will be growth in threats to grid infrastructure, particularly from cyber attacks. The cyber attacks that we're seeing are more numerous and, frankly, more complex. Another megatrend is growth in distributed energy resources and electric vehicles. This program is specifically designed to help us embrace that technology when it comes to private distributed energy resources, and not just embrace it, leverage it to its fullest extent. Another megatrend that the program is designed for, it would be environmental commitments that are being made by our customers to their shareholders and to their own customers about how they want to be sustainable and operate in sustainable territories. Also, state and local commitments to things like carbon reduction. That's a mega trend that's certainly not going away, and we at the company, at Duke Energy, have our own carbon reduction goals. So, no, the primary purpose of this program is not reliability improvements. Is it a benefit that comes along with some of those investments? It absolutely is, and I'm excited about that. I think our customers will value that, but that was not the purpose of the improvement plan.
All right, so you agree that the program, if enacted, if the investments are actually made, will have a positive impact on grid reliability. That is, will reduce the amount of outage times.
I agree with that.
All right. During 2018, what was the approximate percentage of reliability for Duke Carolinas and Duke Progress? Meaning simply, if the power's on every hour of the year, that's 100%, and then you have outages, and that detracts from that. Isn't it true that both companies had a reliability percentage in excess of 99%?
So I think, if I get this right, what you're probably doing is taking, I just want to make sure I understand the question, if that's all right, taking 87, 60 hours in a year and looking at the available time when electricity was available, and then dividing by 87, 60, is that correct?
Yes.
Yeah, I don't have those exact numbers in front of me. We don't typically measure it that way. We measure it by indices called SAIDI and SAIFI, which indicate how often the typical customer has had a sustained outage in a year, and then what the amount of minutes that the typical customer was actually out in a year. Those numbers I have, and I can certainly talk to, but unfortunately I don't have the number that you're talking about. But I would say it sounds in the reasonable range.
Well, the really underlying point I've tried to make here, Mr. Oliver, is that I guess a sense, a compliment to Duke, in that your percentage of customers being out of power as a function of those 8,700 and some hours a year is really quite small. Am I incorrect about that?
No, you're not incorrect about that. The one thing we need to remember about that, though, is those numbers they exclude extreme weather events, what we call major event days, things like hurricanes and ice storms.
Such as what's going on in the Gulf of Mexico right now.
Yes, sir. And we are potentially preparing to send some help there. I've seen a few emails on that today. But those numbers don't include that. They are meant to be more of a normalized view during non-major events, non-ice storms, non-hurricanes. And I can tell you that the programs that we are implementing as part of the Grid Improvement Plan are going to improve storm response. They're going to improve the amount of customers that are affected. I can give you a recent example I hope can illustrate that. We, back in February, I believe, of 2020, we had some pretty severe tornadoes that came through the state. I remember I was on the 46th floor of the Duke Energy building in Charlotte, and we had the sequester there in the middle. It was really that severe. We had severe damage that occurred to our system that day. We had a self-optimizing grid network that had just been enabled a couple of weeks before that. Because of that enablement, we got about 3,000 customers that would have been out for about 24 hours. This was in the Matthews area, Matthews, North Carolina, that were in fact out for only about 5 minutes while that system automatically reconfigured. Now, that's not going to show up in SAIDI or safety numbers, and it's not going to show up in the numbers that you quoted, Mr. Page, because it occurred during an extreme weather event. However, I can tell you those customers are very grateful that they were in service during that time frame. So while I'm very proud of the reliability record of Duke Energy, it doesn't necessarily always include everything our customers see, because our customers do experience those extreme weather events.
Now, I guess my point was that to the extent that the GIP program is intended to have a positive impact on outages and outage times, you really don't have that much room for improvement, do you?
Well, I think there's always room for improvement. That is a measure of excellence that our company strives for. And any measure of improvement that we think can help our customers, as long as it makes sense and is prudently done, it's something we're going to look at. So yeah, I think reliability improvements for our customers, whether they are major event day, extreme weather events, or normal reliability improvements during what we might call the blue sky day, I think our customers appreciate that.
Has Duke conducted any customer surveys to try to ascertain how much in additional rates your customers would be willing to pay in order for the types of grid improvements that you and I have been talking about here today, provided by the GIP program?
I'm unaware of, if we have done that, I'm unaware of that. So I can't answer that.
Would you be aware of any such polling back when it related to the apparently now discarded Power Forward program?
It may have been done back then, but I'm unaware of that and would be unable to comment.
Would you agree that given the fact you already have such a high service reliability index, that there's probably a limited amount that customers would cheerfully and willingly pay for the improvements that are promised by the GIP program?
Well, the improvements that are promised by the GIP program are broad in nature. Reliability improvements are certainly part of that, and I'm excited about that, but that is not the main purpose behind the Grid Improvement Plan. The Grid Improvement Plan addresses the megatrends affecting North Carolina. It prepares the grid for growth in private distributed energy resources, prepares the grid for growth in electric vehicles. These are things that all customers will enjoy. I think there is a qualitative benefit associated with that is very, very important. Protects the grid from cyber threats, allows us to communicate more effectively with our customers because of the automation and system intelligence that we have. And yes, there will be reliability improvements associated with the Grid Improvement Plan. And I'm proud to say that, particularly those reliability improvements in extreme weather events when our customers really need them the most. Now, I have been on the front line in hurricane restoration since I began working in the electric utility industry right out of college in 1988. It is something to see when you can't get a large neighborhood back in power after a long time without it, particularly during, say, the hot months that are hurricane season and the cold months that are ice storms. The Grid Improvement Plan is going to benefit that. It's going to reduce the amount of customers that are out during that time frame. And yes, there will be reliability improvements. So I think it's very important to remember, this is not a plan specifically about improving reliability. What's good about the plan, what's good about the programs, specifically good that we're implementing, is the same work that you do to prepare the system for two-way power flow, the same work that you do to provide system intelligence needed to effectively leverage distributed energy resources on the private side happens to provide reliability improvements. I think that's a great thing, and that's exactly what this plan is all about.
Are you familiar with the marketing spots that Duke runs on television, telling customers about the bright energy future and so forth that Duke has in store for them?
Yes, sir. I think it's a smarter energy future.
Smarter energy future. In any of those spots and advertisements, does Duke say anything about how much it's going to cost the customer in additional rates to be able to get these benefits?
Well, I may not have seen all of them, but I don't think it does. I don't want to postulate, but I don't think that comes up. I do think it's important to point out, though, the benefits associated with these programs, reduction in storm costs, that's going to happen. The IBVC program, as part of the grid improvement plan, will in fact reduce customer costs, reduce fuel charges. All of those things are very positive. And again, enabling us to fully leverage distributed energy resources to their maximum value provides value for our customers. So, but I'm not aware of specifically what you're asking about in that question.
All right, you are aware that in a regulated environment such as the one in which we are living today, each of your several million individual customers don't get to make that cost benefit analysis and choice. That choice, in essence, is made for them by the orders of the Utilities Commission. Would you agree with that?
I would.
That's all that I have for you, sir. Have a good day.
You too, sir.
All right. Next up, we have NC Warren. Mr. Quinn, you're muted.
Thank you very much. Thank you, Madam Chair. I appreciate the introduction, and Mr. Oliver, I appreciate you being here today. I represent NC Warren, who is the intervener in this docket, and I'd like to pick up our conversation on a topic that Mr. Page discussed with you. You probably recall during the early parts of Mr. Page's conversation with yourself, a discussion of an earnings call and some comments which were made during that earnings call. Do you recall that?
I certainly recall that discussion with Mr. Page, yes.
Prior to the beginning of this hearing, the parties provided proposed cross-examination exhibits or potential cross-examination exhibits. And so NC Warren, myself, did the same. I'd like to ask you if you could please turn to the document which NC Warren pre-marked as cross-examination exhibit 1.
Okay, we are turning to that here. Let me make a little room at the table. Okay. This one? Okay, I have it.
Thank you. Now, Mr. Oliver, prior to your looking at this document today, have you seen this edited transcript, which purports to be a transcript of an earnings call held on February 16, 2017?
All right, Mr. Quinn, let's go ahead and mark this document.
I apologize. Yes, thank you, Madam Chair. We'd like to mark this document as cross-examination exhibit number 1.
All right, we are going to mark this document as Oliver, NC Warren, cross-examination exhibit number 1.
Mr. Oliver, have you had a chance to look at Oliver NC Warren cross-examination exhibit 1?
No, I have not. I have it in front of me now, though.
Okay. Would you agree with me, sir, that this cross-examination exhibit is an edited transcript from the Duke Energy Corporation earnings call held on February 16 of 2017.
It certainly says that on the title.
Okay. And if you could please turn to the third page of this exhibit.
I'm there.
Okay. And do you see?
Actually, I'm gonna interrupt you, Mr. Quinn. I apologize. We're actually going to mark this document as Oliver Direct, NC Warren Cross-Examination Exhibit 1. So again, just for clarity and for purposes of the record, the document will be marked as Oliver Direct, NC Warren Cross-Examination Exhibit 1.
All right. Thank you. Now, Mr. Oliver, on page 3, would you agree with me that page 3 appears to be a portion of Ms. Lynn Good's comments made during this earnings call? Would you agree with that?
Yes, I would.
Okay. And of course, Ms. Good is the chairperson, president, and CEO of Duke Energy Corporation, correct?
I agree.
And Duke Energy Corporation, of course, is the parent company or holding company for Duke Energy Carolinas and Duke Energy Progress, the two companies it issued during this consolidated portion of the rate hearing, correct?
Agree.
Okay. Now, on page 3, there is a paragraph. I think it's the second full paragraph from the top, and the paragraph begins, "Today we extended." Do you see that?
I do.
Okay. Now, I'd like to ask you or point your direction to the second sentence of that paragraph, which states, read along with me, make sure I don't misquote this. It states, quote, "Our capital plan and regulatory strategy has been designed to produce earnings within this range each year of the 5-year plan." Did I read that correctly, sir?
I believe so.
Okay. Do you have any reason to doubt that that's an accurate transcription of Ms. Good's comments during this earnings call?
I can't remember what took place during that earnings call.
Okay.
I'm going to assume it's accurate.
Okay. And would you agree with Ms. Good's comments that Duke's capital plan and regulatory strategy has been to produce earnings?
You know, I don't know. I'm not involved in earnings calls or in necessarily capital strategies. I am involved in working on the transmission and distribution grid. I lead a team of engineers that are experts in that regard, and we're just not that involved with this financial information. So that's about the best I can say right now.
I understand. So I'd like to switch topics with you, please, sir. I'd like to discuss the company's request for deferral accounting of grid improvement plan expenses.
Okay.
Would you acknowledge that the Utility Commission has traditionally or historically treated deferral accounting as an exception to the general way that we make rates? Is that a fair characterization?
I think that's a better question for our rates witnesses that are more familiar with how historically work has been done in the past. I'm sure they'd be able to answer that appropriately.
Well, then let me ask one more follow-up question about that. Would you acknowledge that the commission has expressed that the use of deferral accounting should be sparing, or that deferral accounting should be used sparingly? Are you familiar with orders of this commission stating that?
I am not. I am familiar with the order in the last rate case, though, where the commission directed us to work with stakeholders collaboratively and come up with a set of programs that could be agreed upon collaboratively, and then to come back to the commission specifically to request deferral accounting treatment. We have done just that.
Okay. And so you have reviewed the order from the commission. I think it was entered in, it was in the last Duke Energy Carolinas rate case, which among other issues involved the Power Forward program. You've reviewed that order?
I have.
Okay. And can we agree that if that order states that deferral accounting is a tool which should be used, quote, sparingly, if the order states that, can we agree that that is indeed what the order says, and that's what the standard that companies must meet in order to achieve deferral accounting?
Objection, Madam Chair. This is Jim Jeffries. Mr. Oliver is not a lawyer, and I'm not sure what the point of asking him to agree that if a document says something, that's what Mr. Quinn's asking him to make a legal interpretation of what the commission's prior order may say. An appropriate question.
Mr. Quinn, can you respond, please?
Yeah, sure. Mr. Oliver is their grid improvement plan expert. He acknowledged that he has read the order. All I've done is ask him that if that's what the order says, and that's what it says, but I don't think it's honestly an issue worth fighting over. I'm happy to move on to another topic.
All right, please move on then.
All right. Mr. Oliver, I'd like to ask you, please, to turn to page 28 of your direct testimony filed in the Duke Energy Carolinas matter.
Okay, I'm there.
All right.
Working the book in the mute, takes a little while.
I understand. I think every time it's my turn to talk, somebody goes, "You're on mute, Matt. You're on mute." So I understand. Now, Mr. Oliver, here at page 28 of your Duke Energy Carolinas direct testimony, you describe the mega trends which you say establish the need for the grid improvement plan. Is that correct?
Yes.
Okay. And is it also fair to say that in your pre-filed testimony in the Duke Energy Progress case, you provided the same list of megatrends?
Yes, I believe that's true.
So at least insofar as Duke Energy Carolinas and Duke Energy Progress are concerned, the exact same reasons are being cited in favor of the need of the grid improvement plan. Is that fair to say?
It is fair to say. We looked at the plan based on the state of North Carolina. That's how the megatrends were affecting us. And so they affected both of the utilities.
Then I'd like to ask you about a few of the items on this list. First of all, I'm sure you would agree with me that reason number 6 is, quote, the number, severity, and impact of weather events in DE Carolinas customers have been increasing significantly. Did I read that correctly?
You did.
Okay. Now, and the same reason as we discussed was also cited in the Duke Energy Progress docket, correct?
Yes.
Okay. Now, you would agree with me that the frequency and severity of weather events is an issue that is impacting all states within the United States, or almost all states within the United States. Would you agree with that?
Well, I'm not an expert on all states in the United States. I certainly can say that the number of hurricanes and tropical storms that we've been seeing in the Duke Energy Territory, which includes Florida, is increasing, and they tend to last longer. They tend to hang around a little bit longer. We had, I think, two 500-year floods in a span of 3 years. So the weather is certainly changing in the states that we serve, and we recognize that.
Mr. Oliver, is it fair to say that an increase in the severity and frequency of weather events, of significant weather events, is not unique to North Carolina?
I think that is fair to say. Again, we also serve South Carolina. We also serve Florida. And we've seen increase in severe weather there as well.
Now, Mr. Albright, also, I'd like to ask you about another mega trend listed in your testimony, and that is item number 7, which states, quote, "The threat of physical and cyber attacks on grid infrastructure is more sophisticated and is on the rise." Did I read that correctly?
Yes.
All right, Mr. Quinn, I'm going to interrupt you one more time before you get to your line of questions on this on this next trend. We are going to break for lunch now, so we will go off the record. We will come back on the record at 2:15. Please mute your lines and turn off your video. Thank you.
Commissioner Hughes.
Hey, Kirk. I see you there. Do you want to test your audio?
Yeah, I do. Is that all right?
Yeah, go right ahead.
Okay, so it sounds like you can hear me.
I think you sound great. Yeah. Leave it up, just leave it open for a minute and then talk a couple seconds. Sometimes we get feedback with dead air. So I don't think I'm getting that with you right now. So I think you're good.
Okay.
Do you want to test your space bar? You can now use your space bar to talk. What you need to do is mute yourself and then hold it down, sort of like a walkie-talkie. You have to mute yourself first. You want to try it? You don't have to, but then hold down your space bar.
Yeah, I like that.
There you go.
It's a very neat tool.
Yeah.
I was unaware of that, so thank you.
All right, there you go. All right, thank you for checking in.
My pleasure.
All right, thanks.
Hello, is anyone on commission staff available to do a quick tech check with me?
Hi, Deidre, it's Heather.
Hi, Heather. I think we have a couple minutes. Do you mind just seeing if you can hear me when I try to speak through my headphones instead of my speaker on the computer?
Yeah, I'm happy to do so.
Thank you so much. All right, bear with me just a second.
Sure.
Earlier and it was not working. Are you able to hear me now?
I can't hear you. It's not as good as actually before you had your headphones on. You sound very far away.
Yeah, I didn't think these were going to work out very well. They're my daughters. I'll just stick with the I'll just stick with the computer headset. Thanks. I mean the computer speakers and mic. It'll work.
Okay, take them off and test it though, because sometimes we've had trouble people getting them unconnected.
Thanks. Yeah, I think when I turn it off, it'll revert to the computer audio. Hang on just a sec. So it wreaks havoc with my hair. Can you hear me okay?
That sounds good. That sounds better. Do you want to test your space bar? Do you want to work on that? You don't have to, but I'm offering to try it.
That's okay, thanks, because it's given my setup, it's actually easier just to click the mic button.
Okay, all right.
Heather.
Thanks, bye.
Bye, bye. Now I can't figure out how to turn the camera on.
If you found it.
All right, it's 2:15, so let's go back on the record, please. Mr. Quinn, we're with you.
Madam Chair, this is Jim Jeffries. If I may, I have one procedural matter that I'd like to bring up before Mr. Quinn begins, if that's all right.
Mr. Jeffries, proceed, please.
Thank you. I apologize for this. I had a script for introducing all the various pre-filed testimony this morning, and I'm told that I apparently still managed to mess it up. So the issue was with the joint testimony that was filed by Mr. Oliver and Ms. McManus on the GIP issues, and that was for the DEC case. And then there was joint testimony filed by Mr. Oliver and Ms. Smith in the DEP case, and I'm told I may have inadvertently moved that they be copied into the record or that they be accepted into the record as if given orally from the stand in the wrong cases. So I would just clarify what previously our joint testimony of Mr. Oliver and Mr. McManus should be entered in the DEC E7 sub 1214 case, and the joint testimony of Oliver and Smith should be entered into the record in the DEP, the E7 sub 1219 case.
All right, thank you for that clarification, Mr. Jeffries. All right, any other preliminary?
Oh, apologies. Chair Mitchell, Bridget Lee for Sierra Club. I have one question on.
All right, please proceed, Ms. Lee.
Just understanding that we don't have a set end time for the consolidated portion, does the commission anticipate any gap between the end of these consolidated hearings and the beginning of the DEC specific hearings?
The commission does anticipate a break between the two hearings.
Appreciate that. Thank you.
Any additional matters before we get back to the cross-examination of Mr. Oliver? All right, hearing none, Mr. Quinn, you may proceed. Thank you.
Thank you, Chair Mitchell. And is my mic on, or can y'all hear me? Hello?
I can hear you.
Okay, thank you. Okay, Mr. Oliver, thank you. I hope you had a good lunch. I think where we left off, we were discussing the megatrends which you say justify the grid improvement plan, and we were going through some of those megatrends listed in your Duke Energy Carolinas and Duke Energy Progress pre-filed direct testimony. And next, I was going to ask you about a megatrend for the threat of physical and cyber attacks on grid infrastructure. Do you see that in your pre-filed testimony, sir?
Yes, I do.
Okay. Mr. Oliver, would you not agree that taking action against the threat of physical and cyber attacks is something that any utility should perform just in the normal course of providing electric service?
Well, I certainly can't speak for other utilities, but for Duke Energy and its utilities, we take this very seriously. The issue with cyber attacks is the sheer volume of attacks that we see today, the vulnerabilities that we have on the system today, and the complexity of those attacks. We really need to be able to wirelessly patch, for lack of a better term, thousands of devices in the field as we uncover the different types of threats that we see. So it's certainly something that we do. The difference is really the volume, the complexity, and the scale.
Mr. Oliver, do you have any evidence that the volume, complexity, or scale of the physical or cyber attacks being experienced by the companies is unique or worse than other public utilities throughout the nation?
I can't address what other utilities see. I can address what Duke sees.
Adish, I'd like to now switch to another of the reasons for the grid improvement plan provided in your pre-filed testimony. You also cited an increase in environmental commitments from the international to local level. Is that correct?
It is.
Mr. Oliver, I'm sure you would agree that environmental regulations change regularly. Is that fair to say?
I'm not an expert in environmental regulation, but I would guess that's fair to say.
Would you agree that complying with changing environmental regulations is a customary part of any public utilities standard business operation?
I would generally agree with that. However, that is not what this megatrend is about. This megatrend is much more about private companies, for example, on our system that are implementing sustainability goals. It is not unusual for companies like that when they are looking to locate in areas to check in with the utility to see if if working with that utility, they'd be able to reach their sustainability goals. They may not locate in your territory if you can't provide them avenues to do that. It's also about, a good example of this would be the governor's clean energy plan. Whereas that's not necessarily an environmental commitment like the time frame in which we need to deal with an oil spill from a transformer. It's much more about a vision of the future. So it's a little different, I think, than what you're describing.
While we're discussing the cited needs for the grid improvement plan, I'd like to just briefly ask you about the current state of the company's grid. My recollection is that during your summary of your pre-filed testimony, your pre-filed direct testimony, you indicated that overall the grid is reliable and well maintained. Is that a correct representation of a portion of your summary of your direct testimony?
It is.
And would you agree that the achievement of this reliable and well-maintained grid, that was achieved without deferral accounting treatment, without the deferral accounting treatment sought by the companies in this docket, or in these dockets?
I would agree with that.
Mr. Oliver, I think earlier during our conversation, we had briefly mentioned the Power Forward program, which was previously proposed by Duke Energy Carolinas. Are you generally familiar with that Power Forward proposal?
I'm generally familiar with it, yes.
Okay.
It's been a while since I've seen the details of that, but I'm familiar with it.
Okay, very good. My understanding is that during the last Duke Energy Carolinas last rate case, this Power Forward program was proposed, and that as an alternative to a rider to recover costs, Duke Energy Carolinas sought a deferral accounting through the establishment of a regulatory asset for Power Forward costs. Is that an accurate statement of the Power Forward request in the prior Duke Energy Carolinas docket?
I'm subject to check. I do remember something like that. Yes, I was not the witness in that case, so I'm not 100% sure, but subject to check. That sounds reasonable.
And are you aware that the commission rejected both the rider request and the deferral accounting request for the Power Forward program?
Now that I'm much more familiar with. I read the commission's order, particularly the reasons for that, and also paid close attention to the direction that they gave us to convene a group of stakeholders and work through those stakeholders to come up with programs that were more agreeable, that made more sense to a broader group of stakeholders, and we have done just that.
Would you agree with me that there is a substantial overlap between the programs described in Duke Energy Carolinas' prior Power Forward program and the currently proposed grid improvement plan?
I would not.
I'd like to then speak with you just about a few of the programs. My understanding is that the grid improvement plan contains a distribution hardening and resiliency sub-program. I hope I'm using the right phrase, sub-program there, but would you agree with me that distribution hardening and resiliency is part of the grid improvement plan?
No, the settlement agreement that we have signed with many stakeholders does not include traditional distribution hardening and resiliency programs in it.
Okay. What about self-optimizing grid? Is that part of the grid improvement plan that is currently being proposed by the companies?
Yes, it is.
Okay. And would you also agree with me that a self-optimizing grid program was part of the Power Forward previously proposed by Duke Energy Carolinas?
Yes, in that case, I would agree. Now, as I recall, in the Power Forward program, it was a much smaller piece of that program. And in the GIP today is a much larger piece because self-optimizing grid is really one of the core pieces to achieving two-way power flow and system intelligence and control.
Would you agree with me that targeted undergrounding is part of the grid improvement plan that is currently being proposed by the companies?
I would not.
Okay, why is that?
It's not part of the settlement agreement that we've agreed upon with our stakeholders for deferral accounting treatment.
Okay. What about physical and cyber security? Is that part of the grid improvement plan currently being proposed?
Cybersecurity is, yes, not physical.
Okay. And cybersecurity, was that part of the Power Forward program previously proposed by Duke Energy Carolinas?
I don't recall if cybersecurity was. That would be something I would need to check and go back and look at those programs.
Okay. You could just bear with me for just a second. I want to make sure I haven't missed anything.
Yes, sir.
Mr. Oliver, I appreciate you speaking with me this afternoon. I have no more questions at this time.
I appreciate your time. Thank you.
All right, tech customers.
Thank you, Chair Mitchell. Mr. Oliver, good afternoon. My name is Matt Tynan with Brooks Pierce for the tech customers. Thank you for your time this afternoon.
Hello, Mr. Tynan.
You've talked a lot about today and in your direct testimony about the collaborative stakeholder process that led to the grid improvement plan. Is that fair to say?
Yes.
Do you have the exhibits to your direct testimony handy?
I do. Let me pull that book out here and stand up for a minute. That's okay. And you may notice I move around a little bit. I have a bit of a sore back, so I kind of twist a little bit in my chair.
I'm looking specifically at Exhibit 16.
Okay. Exhibit 16, July 2nd, 2019, North Carolina GIP Workshop Report.
That's correct.
Okay.
If you could turn to page 19 of that document.
Yes. There's quite a bit of exhibits here. Let me work through that. Okay, July 2nd, 2019, and page 19 of that document.
If you look at the first bullet point on that page, it says, some who stood at the end of completely disagree end of the spectrum commented that Duke Energy's stakeholder engagement is ingenuine, given it was a requirement of the commission, and given the original Power Forward plan was filed without stakeholder engagement. In addition, one participant stated that this is the third workshop and we still have not seen feedback incorporated. You see that?
I do.
You turn to page 20, second set of bullet points. The third bullet point down says, many stakeholders stated that this process should have been undertaken prior to the filing and before the design of the GIP in order for there to be collaboration on the principles of the draft plan and end goals, and consequently buy-in. Do you see that?
I do, and the vast majority of this process did take place before we filed the plan.
And you'll see that the fourth bullet point on that page states, stakeholders were generally interested in seeing evidence and/or explicit explanations demonstrating how their thoughts and feedback in the stakeholder engagement process were being incorporated. Do you see that?
I do see that.
And if you look at the third to last bullet point on that page, it states, some stakeholders felt that their feedback was not being incorporated or informing the GIP filing later this year. You see that?
I do. I would say this was an iterative part of the process, stakeholder engagement. We had many different workshops. It involved webinars. It involved using cost-benefit analyses, and there are different points along the way. This was a point along the way where we were still working to figure out exactly what this plan is going to look like, and pretty proud with where we landed. In fact, with stakeholder engagement.
Mr. Oliver, this is the report from the last stakeholder engagement meeting that was held before the GIP plan was filed with the commission. Isn't that right?
I don't know that answer. We can certainly check on that.
If you look at page 25 of that exhibit, second bullet point states, disheartening to learn that stakeholder feedback wasn't included in phase 1 of grid modernization and that Duke has ignored stakeholder feedback that a rate case is the wrong venue to discuss. Do you see that?
I do see that.
Now on the following page, page 26, the last paragraph on that page, starting at the second sentence, it says, many of the comments from participants voiced frustrations with the level of commitment from Duke Energy in incorporating feedback and implementing collaborative ideas into the plan. Several comments include, it's the same conversation as the last two, but nothing has come of those. Not sure on the opportunity for changes to this plan since it is being characterized as almost ready to file, and that there are hangups on what Duke is already moving forward with. Do you see that?
Yes.
Is it fair to say, Mr. Oliver, that prior to the filing of this rate case, there was no consensus among stakeholders regarding the programs that should be included in the grid improvement program?
We had a very diverse set of stakeholders ranging from environmental groups to commercial customers, industrial customers, groups that represent the public, like public staff, low-income groups. So it's pretty difficult to reach consensus during those workshops. However, stakeholder engagement is an iterative process. It involves a lot of different things. This was step one. The workshops were the beginning. And I think that's what really led us to be able to complete the process successfully. And that process culminated in the signing of those settlement agreements. So this was one point in an iterative process that took several years to complete. So I think I would agree with you. There was no consensus at that time. There is general consensus now.
We'll get back to that, but is it fair to say that at least some stakeholders were dissatisfied with stakeholders' ability to provide influence on what became the grid improvement plan?
At that time, I would agree.
And you would agree that still today there are stakeholders who don't agree with the grid improvement plan that DEC has proposed. Isn't that right?
Yes, we have not reached agreement with all the stakeholders.
On page 47 of your direct testimony, you describe certain changes to the GIP that resulted from the stakeholder process. At lines 13 to 15, you state, most notably, the IVVC program was added. The targeted undergrounding program was significantly reduced, and much of the distribution H&R work was moved out of the plan. Do you see that?
I'm still working on getting to page 47.
Okay, I'll give you a second.
Yeah, sorry about that.
That's fine.
I'm on page 47, and I did hear what you said, and I can see it here on the page.
Is that still your testimony today?
Company made significant changes to the portfolio of investments. Most notably, the IVVC program was added. That is true. Targeted undergrounding program was significantly reduced, and much of the distribution H&R work was moved out of the plan. At the time of the testimony, that was true. Now, in our settlement agreements that were the culmination of the stakeholder engagement process, we don't have targeted undergrounding in the plan, and we don't have distribution H&R in the plan at all. So it has changed a little bit.
Would you agree that the addition of IVVC was one of the biggest changes from the Power Forward plan to the grid improvement program?
It's certainly a big change. It's a very important program. It addresses many of the mega trends, which was the purpose of the GIP.
Duke was already looking into an IVVC program in 2018 prior to the beginning of the stakeholder process, wasn't it?
Yes, we had some conversations with stakeholders at that time, and we're understanding that there was a pretty strong desire for IVVC to be included, and we certainly took that into consideration and included it in the plan.
Do you think that IVVC is properly considered a grid modernization program?
Absolutely.
Is it something that DEC would have included in its grid improvement plan, even if no stakeholder had suggested it?
You know, that's a good question. I don't know that I can answer it, but certainly, since it was part of the stakeholder engagement process and addressed the megatrends, it made perfect sense to put into this plan.
Mr. Oliver, in the second agreement and stipulation of partial settlement that DEC entered into with the public staff, DEC agreed that it would withdraw its request for deferral accounting of all programs besides self-optimizing grid, IVVC, ISOP, transmission system intelligence, distribution automation, power electronics, DER dispatch tool, and cybersecurity. Is that right?
That sounds correct. Yes.
Duke's agreement to withdraw the request for deferral accounting for those other programs is a compromise by DEC. Isn't that right?
Well, I think it's the result of a good stakeholder engagement process. Stakeholders have input. They agree to certain things, and you know, I believe in those programs that we removed. However, as part of our stakeholder process, we agreed to take those out of deferral accounting treatment.
Is DEC's agreement to withdraw the request for a deferral accounting for those other programs an admission that those other programs were not truly grid modernization programs?
I am going to, I believe in the settlement agreements. The settlement agreements make sense for all of our stakeholders. They make sense for us. They make sense for our customers. However, those programs are important, whether you call them grid modernization or not. They're still programs that we'll look at where we can. But what I call something, I don't know matters all that much. There are schools of thought out there that would say something like targeted underground is a grid modernization program. And they would say that because when we put those lines, overhead lines behind people's homes in the 50s and 60s, we did that because we didn't have bucket trucks. And it didn't matter where the lines were located. We had to climb them anyway. We have bucket trucks now, have for many years. We don't put generally don't put lines behind people's homes anymore. So I could say that that program would be modernizing a design that is outdated. But that's just what I would say. And it's not what we agreed upon with our stakeholders.
Maybe I unnecessarily put you on your guard with that question. I guess my question was, the settlement agreement with the public staff is not an admission that the programs that DEC agreed to exclude were not grid modernization. Is that right?
Chair Mitchell, this is Mr. Jeffries. I don't have an objection so much as I do a definitional issue with the words Mr. Tynan is using. The program that Mr. Oliver is testifying about is called the Grid Improvement Program, and there are 3 types of sub-programs that fall underneath that: modernization, optimization, and protection. And I'm a little concerned that we may be talking past each other because Mr. Tynan seems to be referring to all of them as modernization programs.
All right, Mr. Tynan, what's your response?
I'll try to be a little bit more careful with how I'm asking the questions.
Okay, please proceed.
Is it fair to say that DEC's agreement to withdraw certain programs from the grid improvement plan request for deferral accounting in this case was not an admission that deferral accounting would be inappropriate for those projects or programs?
I'm going to answer that question the best way I can. The programs that are remaining for deferral accounting treatment are those that solve for the most megatrends. I think that's a very important way to look at it. As far as how accounting treatment is given to the remaining programs, I think it's pretty straightforward. We're not going to seek deferral accounting for those programs.
But your decision, DEC's decision not to pursue deferral accounting for those programs isn't because DEC suddenly realized on the eve of this hearing that those programs were not worthy of deferral accounting. Is that fair to say?
I think it was the result of stakeholder engagement and the result of compromise.
It was a result of compromise and give and take with the different stakeholders. Is that right?
Yes, particularly on the type of programs that would be included for deferral. We did exactly what the commission asked us to do in its last order.
In fact, the stipulation with the public staff states that it reflects a give and take of contested issues. Is that right?
I don't have that in front of me. I guess someone could put it in front of me. I could, say yes or no. I don't.
Subject to check, would you agree that the stipulation filed with the commission states that it reflects a give and take of contested issues?
Yes, subject to check. Yeah.
In the summary of your testimony that you presented today, you stated, as the culmination of the GIP stakeholder process initiated by the commission at the end of our last base rate cases, we have now concluded settlements with most parties who took a position on our GIP proposals. My question is, the settlements that were reached with the parties who did settle with DEC was not truly a stakeholder engagement process, was it?
I disagree. I was involved in some of those conversations, particularly on the GIP programs, and it was certainly a stakeholder engagement process.
But the settlement agreements entered into by DEC are not limited to grid improvement plan issues, are they?
That's a correct statement. They are not.
Those settlements, like the settlement between DEC and the public staff, reflect a give and take or a compromise between the parties about the issues they settled. Is that right?
Yeah, I think we talked about that before. I think that's a reasonable thing to say.
So the parties to the settlements, various settlements, just made concessions to each other to reach agreement on whole sets of issues all at once. Is that fair to say?
can't say why the public staff or any other party reaches a settlement agreement. That is, I certainly can't get in their head and understand why they do it. What I can say is we work very closely with those stakeholders, and they support the deferral of certain GIP programs, and we are in agreement with those.
Mr. Oliver, do you believe that the NC Justice Center would have been willing to agree to deferral of accounting for GIP programs if DEC had not agreed to pay $6 million to the Helping Home Fund that's specified in the settlement agreement between DEC and the Justice Center?
I have no idea what the Justice Center would agree to or not. That's probably a question best for them.
Do you know whether NCSEA would have been willing to agree to deferral accounting for GIP programs if DEC had not agreed to the 7 distributed energy initiatives, including distributed generation guidance and hosting capacity analyses that were specified in the settlement agreement between DEC and NCSEA?
Again, I don't know what they would have agreed to or not have agreed to. I do know what they have agreed to.
Mr. Oliver, do you know whether SIGFR would have been willing to agree to deferral accounting for GIP programs if DEC had not agreed to cost allocation and rate design concessions that were specified in the settlement agreement between DEC and SIGFR?
Madam Chair, objection. This is Christina Kress. I apologize, Mr. Jeffries.
I'm sorry. I think we chimed in for the same point. This is asking for speculation on the part of Mr. Oliver about what other people were thinking and may or may not have agreed to, and that it's objectionable, Your Honor.
Objection for the same reason. This is an inappropriate line of questioning for this witness. And my understanding is that Tech Customers has waived cross-examination of SIGFR's witness. That would have been the witness to whom this question would have been more appropriately directed.
All right, thank you, Mr. Kress and Ms. Kress and Mr. Jeffries. Mr. Tynan, would you please respond?
I'll try to rephrase my questions, Chair Mitchell. Thank you. Mr. Oliver, it's the case that each of the parties who settled with DEC received concessions from DEC unrelated to the GIP plan. Is that fair to say?
Well, I think we'd have to review each of the agreements individually to take a look at that and determine if that's the case. We can certainly take the time to do that, but I know there are multiple agreements where more than just the GIP was discussed.
Mr. Oliver, why should the commission give any weight or consideration to consensus with stakeholders that DEC has bought through the various settlement agreements?
Objection, Your Honor.
All right, state your objection, Mr. Jeffries.
There's been no testimony by the witness that DEC or DEP bought anybody's consideration. Instead, what was described was the process through which the parties were able to reach settlement. I mean, that's fine. If Mr. Tynan wants to put that in a brief, that's fine, but that's an improper question.
All right, Mr. Tynan, would you respond, please?
DEC traded things of value to the different parties. I think that, you know, my choice of the word bought is a fair construction of what they did.
All right, I'm going to sustain the objection. Let's go on. Please move on, Mr. Tynan.
Mr. Oliver, stepping back a bit, isn't it true that grid modernization and grid improvement is something that will have to take place over decades?
Well, I think in some cases that's true. In other cases, the need is much more urgent. We're getting ready to reach a tipping point for certain technologies. Electric vehicles is an example where we're close to reaching that tipping point. And the grid needs to be ready for that when we reach it. Part of what we're doing with the agreed upon grid improvement plan is just that, with our two-way power flow and system intelligence projects that are part of the GIP. So some are much more urgent than others, but the evolving nature of the grid is certainly going to take time. The programs that we have postulated in our settlement agreements as part of the GIP are those that are the most urgent today.
Wasn't DEC's Power Forward plan a 10-year plan?
I believe that's the case, yes.
And hasn't DEC been implementing grid modernization technologies for more than a decade already at this point?
I think it depends on your definition of grid modernization. We've kind of been through that before, but a program like IVVC, for example, no, we've not been implementing IVVC. That's starting this year. Programs like the Advanced Distribution Planning Tool that is part of the ISOP process largely is underway now as well because of working closely with stakeholders. There are some aspects of the grid improvement plan, particularly some of the cyber security work that has been implemented in the past. An example might be as we go out and upgrade modems for line control devices from 2G, 3G technology up to 4G LTE. We've installed door alarming capability on those devices, so we have the ability to know if the device has been tampered with, and it's important physical and cybersecurity aspects. There are some aspects, but they tend to be very small compared to what we're putting forward in the current GIP.
Mr. Oliver, will DEC be finished modernizing and improving the grid after the completion of the 3-year GIP program that's proposed here?
I don't think so. I think at the end of this plan, as we work with stakeholders and determine if there is a next step, we'll make that decision then, and we would file something at that time for consideration of the commission. Things could change in 3 years. However, the programs that we are postulating now in this 3-year plan are simply foundational. Having the ability for two-way power flow, switching from the one-way grid of today, moving from managing the grid in circuits to managing the grid in segments, which is really the core of two-way power flow, the core of being able to fully leverage private distributed energy resources. That's simply foundational to no matter what the future is. So those programs are really the core. That's where we're at. We'll reevaluate when the time comes, work with our stakeholders, just like we've done now. It takes a long time to work with stakeholders, as we've talked about, but I think it's worth it when we can reach productive agreements like we did here. And then we would potentially put forward a plan at that time.
Mr. Oliver, would you agree that there's no set timeline under which the programs that are proposed in the GIP program and set forth in the settlement agreement with public staff, there's no set timeline under which those programs must be implemented?
I guess I would agree with that. Our plan is to implement them in 3 years. And that's how we've set the plan up. It's 20, 21, and 22. We are gearing up our project management organizations. I meet with those groups on a routine basis. My engineers on my team are involved in the planning and the engineering associated with moving on these projects. So we're looking at a 3-year plan.
But the 3-year plan and the programs in it could be extended out to 5 years or 10 years or more if that's what DEC decided to do. Isn't that right?
Well, if that's what we decided to do, I suppose that's true. I would counsel against that. The programs that we're talking about here are urgent. It's very important that we start now. It takes a long time to change the grid we have. It took 100 years to build it. And changing that grid to where it needs to be in the future is not going to happen overnight. So the foundational programs that we've agreed upon with many stakeholders in this process are just that. That is the beginning foundation of changing this grid to where it needs to be. to incorporate all the different aspects of the future.
Mr. Oliver, at page 54, line 21, to page 55, line 4 in your direct testimony, you refer to outcomes that may occur if the commission determines not to grant the regulatory asset treatment for the company's GIP plan. And you state that in such a situation, the company would have to try and perform small pieces of the grid improvement plan over a much longer period with its existing revenues, which will delay important benefits and potentially essential improvements for customers.
Okay.
You see that?
I heard you, and I'm working to get to page 54. Sorry, I'm a little slow.
That's just fine.
I'm here, and I see the lines that you have highlighted.
Is it still your testimony, given the smaller set of projects to which DEC has agreed to seek deferral accounting with the public staff, that in the absence of deferral accounting, DEC would be required to try to perform small pieces of those programs over a longer period of time?
It is.
Mr. Oliver, do you have the potential cross-examination exhibits from tech customers available?
We do.
If you could please turn to what was pre-marked Tech Customers Exhibit 29. And Madam Chair, I ask that this be marked as Oliver Direct Tech Customers Cross Exhibit 1. Mr. Oliver, this should be DEC response to data request, to Tech Customers data request number 6, item number 615. Is that what you have?
All right, hang on one second, Mr. Tynan. Let's go ahead and mark, we'll mark the exhibit as Oliver Direct Tech Customers Cross-Examination Exhibit number 1.
Mr. Oliver, do you have, is it the data response to item number 615?
Yes, sir, I do.
If you look at request 15A, it states, or it asks, has DEC estimated what grid improvement plan programs and projects it would undertake and the timing of these in the absence of the Commission's approval of deferral of grid improvement plan expenses? Please provide estimates. And then if you look at the response below, the answer is no. You see that?
I do.
Is that correct?
That certainly was correct at the time. We have recently filed updated testimony in which we were asked to postulate something like that by the Commission, and we have done so. But at the time, the answer was no.
Mr. Oliver, were you referring to the joint testimony of J.W. Oliver and Jane L. McManus that was filed on August 5th, 2020?
Yes, I believe if we had done that at the time of this question, that may have been how we would have answered, is to see that testimony.
Is it a fair characterization of that testimony that it does not reflect what DEC actually plans to do in the absence of deferral accounting?
Well, so it becomes pretty complicated to estimate what we would do in the absence of deferral accounting. And I think Witness Young yesterday and today explained that. What we do with the cash flows that we have from base operations is really covered in my Exhibit 1. And that comes first. That's first things we would do. If we do have dollars left over that can be spent to work on these programs, then we certainly do that. The problem is to do it in an effective way, to do it the right way, in a cost-effective way, we need to do them as larger programs. and they're incremental. And that's the whole reason for this request for deferral accounting treatment. It allows us to go, and I'm not an expert in finance. I learned this morning or this afternoon and this morning listening to Mr. Young as well, that we have to go get that money. We need to finance it above and beyond. And we need to pay those investors back eventually, assuming that the commission rules that the expenses at the time that we put them into rate base were in fact prudent and carried out cost effectively. So absent that, we would do it as we had the opportunity. And I believe that is what that testimony states.
In fact, that testimony states that it would be impossible to predict what DEC would do in the absence of deferral accounting. Is that right?
Yeah, there are so many variables that come into play, and they are mentioned in particular in that testimony, that it becomes very difficult to predict what would happen. Energy sales may be up or down. There could be other expenses that come in, such as storms, that we need to deal with. So it's difficult to say what we would do. The advantage of the deferral is allows us to take those programs. They're financed a little separately, incremental, above and beyond base, and we can implement them in a much more cost-effective fashion that way.
Mr. Oliver, is it fair to say that it is essentially impossible to calculate the financial impact on DEC of a denial of deferral accounting?
I don't know that I'm the right witness to ask that question. It sounds like a finance question to me. So we may want to pick another witness for that who's better equipped to answer.
Mr. Oliver, if you could please turn to the joint testimony of J.W. Oliver and Jane L. McManus that was filed on August 5th.
All right.
And if you start at page 4.
I'm there.
At line 4, the question is directed to you. Witness Oliver, has the company prepared the analyses under the 2 scenarios requested by the commission? You see that?
I do.
Is it fair to say that you are the individual giving and sponsoring the testimony that appears on pages 4, 5, 6, 7, 8, 9, and 10 of this testimony?
Yeah, I'm a joint sponsor of this testimony, so yes.
And specifically, you were the individual responding to the questions in this section 2 description of scenarios, is that right?
Yes.
If you look at page 7 of this testimony, line 7, the question is, are there other factors that make the deferral denied rate impact analysis impossible to provide at this point in time? You see that?
I do.
And the answer begins yes. Is that correct?
It is.
And starting at line 17, the answer states, without having a reasonable approximation of what our revenues will be for the designated period, it is literally impossible to calculate prospective cash flows or available capital for investment in GIP programs. You see that?
I do.
Is that testimony correct?
Yes.
If you turn to page 9 of that testimony, the question that begins at line 1 states, do these assumptions, referring to assumptions on the prior pages, reflect reality? And the answer begins, probably not. Do you see that?
I do.
And at beginning at line 12 on that page, it states, the testimony states, so while the company has conducted a deferral denied analysis for purpose of the commission's order, it is purely hypothetical in nature. You see that?
I do, and we make clear why that is the case throughout these questions and answers.
So that testimony is correct?
Yes.
And then on page 10, lines 1 and 2, the end of the sentence states, "We maintain that this analysis likely does not reflect decisions the company will actually make during the period 2020 to 2023. Is that correct?
Yes.
And is that testimony correct as you sit here today?
As far as I know, I don't know of any reason why that would be different. We've explained why it's very difficult for us to determine exactly how much we would be able to do in the deferral denied scenario. We've explained why that's the case. However, we did provide a hypothetical scenario to the best of our ability.
Mr. Oliver, is it fair to say that sitting here today, you can't say that DEC will not pursue self-optimizing grid absent deferral accounting?
Can you say that question again? I'm sorry.
I think I confused myself. I'll try again. Sitting here today, is it true that you don't know whether DEC will pursue self-optimizing grid if deferral accounting is denied?
I would say that we are going to pursue self-optimizing grid if deferral accounting is denied. The problem is we'll have to go in a much slower pace. There'll be some years we may not be able to do any. There'll be some years where we'll be able to do a bit more. We just won't know until all the different factors come into play through that budget season, through revenues, through what storms have come in. And frankly, that's just not the way to effectively implement a program like that. That program is much more effectively implemented with scale, with the right resources, with a dedicated engineering team. And frankly, that's exactly what we propose to do. So, but as I think we've stated before in my testimony, the company would seek to implement those programs just at a much smaller scale and a much slower pace, and I stand behind that.
But sitting here today, you can't tell what that pace would be.
That's true.
Is that fair?
Yeah.
What about the programs that were dropped from the deferral accounting request in DEC's stipulation with the public staff? Does DEC plan to pursue those?
We're gonna look at those programs just the way described in my testimony. We will do them as they can be funded through our normal base process, which means load service comes first, maintaining our reliability where it is today, maintaining the assets that we have in place today, complying with safety, making sure our system is safe to the appropriate measures, environmental compliance, all those things come first and they'll be budgeted first. Some years we'll have money that is left over and extra and can pursue those programs. And other years, it's unlikely that we will. But we're sticking by what's in the testimony. We're gonna do it at a pace and scale that fits the budget that is available.
If the GIP programs are delayed because deferral accounting is denied, the cost of implementing those programs will be delayed. Is that fair to say?
Yes. Also, the benefits of implementing the programs will be delayed.
Right, both the benefits and costs would be delayed depending on when DEC is able to implement them.
Yes, sir.
Does DEC stipulation with the public staff establish any sort of spending cap for GIP expenditures?
Yeah, I don't know that. I'm not familiar with that. I know what our budgets are. That's probably something we can do a quick check on. Maybe that's something our lawyers can follow up on, but we have a budget associated with that work. We have agreed with the public staff to work closely on reporting mechanisms for scope, schedule, and budget. I'm excited to work with the public staff on that. So I expect that we will be watching that very, very closely. But as far as actual caps, that is something that we can check on.
Should DEC's spending on GIP plan programs be limited to the amounts budgeted in your Exhibit 10? If deferral accounting is granted?
I don't know that they aren't at this point. I think we need to take a look at that agreement with the public staff. You know, the company goes through budgets on a routine basis. We are used to meeting our budgets. When we put a plan together that is a 3-year plan, I expect that it's going to come in at that budget. And the folks that are in the field implementing those also expect that of themselves. So frankly, whether there's a cap or not, we're going to implement the programs in the most cost-effective way possible to get the most benefits for our customers possible. So we have no intention of spending more to implement the programs. The budgets are what they are, but certainly we can, check and discuss the cap situation.
Mr. Oliver, could you pull up your revised Oliver Exhibit 7, page 20?
Yes. Let's get the exhibit book. Seven. Take me just a minute here. That's the big CBA books. Yeah, those books are a little different. Bear with me for a minute. We'll get that up.
And at the same time, it'd also be helpful if you can have in front of you your Exhibit 10, page 3.
Okay. Well, I have.
I'm sorry, Mr. Tynan, did you identify a page in Exhibit 7 that you were specifically going to ask about?
Yes, it's revised Oliver Exhibit 7, page 20.
Okay. So we're looking for page 20 in Exhibit 7. There we go. Okay.
That should be Duke Energy Carolina's North Carolina IVBC evaluation. Is that what you have?
Yes, we have that. And then we have Exhibit 10. We're working on getting that. So yep. That's a bigger copy. Okay, we're there.
My question, and this may be just clarifying for me, on your Exhibit 10, page 3, the amount budgeted for capital expenses for IVBC for the next 3 years is approximately $200 million. Is that right?
Yes.
Looking at the total capital for the IVBC evaluation on page 20 of your Exhibit 7, it looks like there's approximately $275 million budgeted for 2020, 2021, and 2022. Is that right?
Are you adding where it says total capital? And so one of the 2020 line would be 40.4 million?
Correct, yeah.
Okay. Yeah, so there's a slight difference there. The Exhibit 10 numbers are CapEx. They don't include cost of removal, and they don't include AFUDC. They also don't include the ongoing revenue requirement. This CBA that was calculated because it's a CBA that is similar that we would use for a power plant. That's the main difference. So
Okay, so the relevant expenses in here would add up to approximately $200 million. Is that right?
I agree.
Okay. On your exhibit 14, page 15, there's a projection for how the reliability of DEC's system will go in the absence of the GIP plan.
Okay, so let me get to exhibit 14, page 15.
Chair Mitchell, this is Christina Kress. Would it be possible while the witness is looking for this exhibit to just take a very quick break? Given the tenor of the cross-examination, I would be remiss if I was not present for any portion of it. And I do need to use the restroom. Can we just take a quick 3 to 5 minute break if possible?
All right, Ms. Kress, we'll take a 5-minute recess. Let's come back on the, we'll go off the record. We'll come back at 3:25. I'll give you a little bit longer than 5 minutes.
Thank you. I appreciate it.
All right, let's go back on the record, please. Mr. Tynan, Mr. Oliver, let's resume.
And I just have a short line of questioning left. I'm going to pull a switcheroo here, Mr. Oliver. Do you have available to you, it's Tech Customers Exhibit 36?
Yes, sir.
Madam Chair, I'd like to ask that this be marked as Oliver Direct Tech Customers Cross-Examination Exhibit 2.
All right, the document will be marked Oliver Direct Tech Customers Cross-Examination Exhibit number 2.
And Mr. Oliver, is what you have the DEC's response to data request number 36, item number 36-4 from the public staff?
It is, sir.
First, just a preliminary question. Mr. Oliver, is it fair to say that the primary economic benefits in the cost benefit analyses submitted in your Exhibit 7, the primary benefit to DEC's customers is reliability improvements?
Not necessarily. There were no reliability improvements in the cost benefit analysis for the integrated boat bar control program. That is a very large part of the deferral programs. Reliability benefits were part, along with hosting capacity benefits, were part of the self-optimizing grid CBA. So, yes.
Mr. Oliver, in response to public staff's data request and number 36-4, DEC's response states in the middle of that paragraph, while we can provide specific reduction estimates for the GIP, we cannot accurately predict system safety and SAIDI scores for future years. Do you see that?
I do.
Is that a correct statement?
Generally it is. SAIDI and safety is affected by many different measures. It's a system measure. Weather causes it to vary dramatically. The amount of major event days we have causes that to vary dramatically depending on what is discounted from SAIDI and safety because it's a major event day or not. But what we can do, as said here, is measure directly the CI and CMI savings from programs like Self-Optimizing Grid.
Isn't it true that you can't measure the savings from Self-Optimizing Grid because what you'd be attempting to measure are outage events that didn't happen?
No, that is not true. We already measure Self-Optimizing Grid and its effects in other states. Ohio, for example, in fact, did a regulatory reporting on that as part of the grid rider there. So with Self-Optimizing Grid, an actual event occurs and the system reconfigures automatically to isolate that particular event. So an outage still does happen, it just affects a smaller number of customers. So we have a history that we can look at and we can predict. Part of my team's job, I have a team of engineers that do reporting for programs at the company. There are several folks, their full-time job is to calculate Self-Optimizing Grid benefits. I am extremely confident that those can be measured.
If I understand you correctly, they're not actually being measured, they're being estimated from historical performance. Is that fair to say?
No, they're being measured. I know exactly how many customers were saved from that outage. Now, earlier today, I gave an example when we had recent tornadoes that occurred in the service territory. And we know exactly how many customers were saved when the system itself performed that automated switching down to the number. It's a fairly straightforward calculation. Then we go in and we estimate how long it would have taken us to get out there and do the first manual restoration step. And that's when we stop the minutes. So we know the customers perfectly, and then we calculate the minutes in a very conservative way by saying the entire outage would have stopped when the first responder arrived and took the first step. So our benefits that we calculate for CMI are actually a little bit understated.
But they're still estimates. Is that fair to say?
The CI estimate, the customer interrupted, that's not an estimate. That is a measure of absolute fact. In fact, the system used for self-optimizing grid calculates that number because it's very straightforward. Where it gets a little more complicated and where it is an estimate is the duration. So we take the lowest number that it could be and use that. So it is an estimate, but it's an estimate on the low side.
Mr. Oliver, do you recall discussing with Mr. Page earlier improvements that are promised, quote, in the GIP plan? Do you remember discussing that?
I don't remember that exact term, but I remember the discussion with Mr. Page for sure.
Is DEC promising that ratepayers will see the reliability improvements that are described in the grid improvement plan in your testimony?
Well, we have agreed with the public staff to a ongoing reporting mechanism. We're going to design that together. And I think that will assure that we're on track and can react if we see that we're not getting the benefits that we thought we were going to get. And also, it's important to point out that this is a deferral mechanism. It does not constitute recovery. Only the commission decides on recovery, and they will decide based on the facts. And if when these programs go into service, the commission determines that they did not provide the benefit that we said they were going to provide, they would take action at that time. So I really don't think there's a need to promise. We're going to start delivering benefits to customers very quickly, and we won't recover the money until we do the next rate case.
If DEC doesn't deliver the reliability improvements described in the cost benefit analyses in your Exhibit 7, should the costs of the grid improvement plan be denied recovery for failure to provide those benefits?
Objection, Madam Chair. This calls for complete speculation by Mr. Oliver. It's a hypothetical. We have no facts of what the situation may be or why the benefits might not have not been obtained. I don't think Mr. Oliver can fairly answer this question.
Mr. Tynan?
If you'll give me just a moment, Madam Chair. In Mr. Oliver's testimony to the South Carolina Commission, just a second. He stated that guarantees weren't necessary because of the possibility of prudence disallowance of certain costs. And Mr. Oliver filed that testimony as one of the exhibits to his testimony, his direct testimony in this case. And that's what I'm asking about.
All right, I'll allow the question. I'll overrule the objection.
And unfortunately now, Mr. Tynan, I forgot the question. Could you repeat it? I'm sorry.
My question is, if DEC fails to deliver the reliability improvements that are described in the cost benefit analyses in your Exhibit 7, should the commission deny DEC cost recovery or grid improvement plan expenses?
Well, that's a question best suited, I would say, for the commission. I would point out that reliability benefits are certainly one aspect of why we implemented the grid improvement plan. Those reliability benefits tend to be those that are that don't occur during extreme weather events. So we're only tracking the minority of benefits there. Also, remember, we implemented these programs in response, or we're going to implement the programs, assuming that they are approved by the commission, to respond to the megatrends. And the megatrends are, I'm going to generally say, supported by the vast majority of parties in the case. There's very little dispute about those. So while reliability is important, frankly, it is a part of my job, my day job. It was not the sole reason that we implemented the grid improvement plan. It's certainly a great benefit for our customers, and the commission will decide as they do, what has been prudently expended and what has not. And it's up to them how they do that.
And should the commission's decision whether to allow Duke to recover grid improvement plan costs be affected by the decision whether or not those costs, excuse me, I'll start over. Should the commission's eventual evaluation of whether Duke can recover the costs of grid improvement plan programs be influenced by whether the commission grants or denies deferral accounting in this case?
Well, deferral accounting is not a approval to recover costs. Deferral accounting is simply an approval for deferral accounting. Recovery comes when it's put into service, and the commission will decide at that time if those costs were incurred prudently.
Thank you, Mr. Oliver. Madam Chair, I have no further questions.
All right, redirect for the witness.
Thank you, Madam Chair. I have a few. Mr. Oliver, do you remember Mr. Page asking you some questions about the relatively high reliability that, at least according to him, Duke provides to its customers now?
I do.
Would it, GIP is not premised on reliability, right?
That's correct. The plan was built to address the megatrends.
And assuming that, based on your experience, if 99% of Duke's customers have power, how does the 1% that doesn't have power feel about life?
Well, it depends on your situation. If that 1% happens to be a industrial customer that is churning out product, it's extremely distressing. If that 1% happens to be a residential customer that maybe has children at home, schooling at home, like happens these days, it would be very difficult for that 1% of customer. If that 1% of customer is a life-sustaining medical equipment account, all of our customers are extremely important, and we strive to serve, provide the best possible service to each. But sometimes it really depends on the situation. Now, I've been, like I said before, involved in storm restoration activities for the vast majority of my career. And I can tell you in certain communities in Eastern North Carolina, when the power goes out and the infrastructure is down during those major events, it is a severe issue in that community if the Walmart doesn't have service, if the gas stations don't have service, and maybe you don't have gas in your car to get to the Walmart. Maybe the well pump doesn't work at your house. So there's a lot of importance to reliability, a lot of importance to what we're doing. And the 99% number is a number. That 1%, whatever it is, certainly can have dire consequences.
Mr. Oliver, one of your mega trends, if I'm recalling correctly, is customer expectations. Is that right?
It is.
has the company done any surveys, any polling, and talked to its customers about the significance of reliability and grid improvement?
Yeah, we do surveys with our customers. We do many different types of surveys, and reliability is one of those. And frankly, our customers expect an extremely reliable grid. That is very straightforward. They expect power the vast majority of the time. When it is out, they expect it to be resolved quickly, and they want to know the reason why. So they're very interested. Customer expectations have certainly changed in recent history. They're used to dealing with large companies that really provide service at a different level than the utility has. We're striving to make that change. We are using technology now to communicate with our customers, give them text alerts, let them know when the power is going to be back on. The other thing our customers expect of us is that we are an environmentally responsible utility. They expect us to embrace green technologies. This is exactly what we're doing as part of the Grid Improvement Plan.
I've heard you use the term perfect power. Is that a thing?
Well, perfect power, I guess, is a thing. Customers will talk about that. They would like no momentary interruptions, certainly no long-term outages, and their expectations in that regard are getting much higher. Everything at the home is electronics these days. It tends to be powered by the AC that comes into your home. Most of it is converted into DC almost immediately to run all the electronics that you have. A momentary interruption can cause your cable box to reboot and take 5-10 minutes to come back on. That really hurts when you're on a Teams meeting, I suppose, and trying to conduct business that way from the house, for example. Some things that are going on through COVID. That also really hurts when there is when a child is attending school from the house. So it's become even more acute today, the reliability, and I believe the company is responding to it. It's our job to respond to it, and part of what the Grid Improvement Plan provides, a part of it, is in fact improvements in reliability.
Thank you, Mr. Oliver. Mr. Quinn asked you some questions that at least I interpreted to be directed to pointing out the fact that North Carolina isn't the only state that's experiencing bad weather or some of the other mega trends that you had identified in your testimony. Does the fact that other states may also be experiencing, or other electric companies may be experiencing, similar types of influences driving their need to improve, optimize, protect their grid, does that hold any significance to you? Does that lessen the justification of the megatrends in your mind?
It does not. I think what's a little bit unique about Duke is the Florida territory, the South Carolina territory, and the North Carolina territory are highly susceptible to hurricanes, as we're seeing right now with the hurricanes that are in the Gulf. So for us, it's a little bit more concerning, and our customers, and we know what our customers expect when it comes to storm response, and we strive to meet those expectations. So I'm more familiar with our territory than other territories, but what's a little bit unique about ours is that exposure to hurricanes.
Thank you. Mr. Quinn also asked you a question about whether cybersecurity was part of the Power Forward program, and I believe you indicated you were not sure on that. Is that right?
That's true. We'll have to follow up on that.
So do you have the Williamson's joint testimony nearby?
We are working on that.
If you could turn to table 1 on page 24.
Okay.
Of at least that's the page number in the DEC filing. Does that help you answer?
We have the DEP version. We're going to get the.
Okay. It should still be table 1. I'm not sure it's exactly the same pages.
Table 3. Now let's get the DEC version. We're getting there. Okay, so we have page 24, testimony
Correct.
of David Williamson and Tommy Williamson Jr. And there is table 1. Yes.
Does that help you answer the question about whether cybersecurity was part of Power Forward or not?
So on the right side, it's got Power Forward programs. It has 0 for physical security and 0 for cybersecurity. It certainly does. Yes.
And the answer would be that neither physical nor cybersecurity were part of Power Forward, correct?
Yes.
Okay.
Yeah.
Could you also turn to, it's right here, your exhibit number 16, please. And again, I'm making reference to the DEC exhibits.
Okay. This one. Sorry for getting up and moving around. Okay, so we have exhibit 16. Yes.
Right, and Mr. Tynan took you through that, and he pointed out to some pages that had some, I think, what I would perceive as negative comments about the stakeholder process. Do you recall that?
I do.
Okay, and one of those was page 19 of 35.
All right, we're moving to that right now. All right, I'm there.
And he had you read the first bullet there of 3 bullets in the middle of that page, which are summaries of participant comments. Could you read the last bullet on that page?
Yes, the last bullet on the page says stakeholders positively acknowledge the use of webinars, pre-reads, needs assessments.
I'm sorry, I gave you the wrong direction. The last bullet of the 3 in the middle of the page.
Yes. At the completely agree end of the spectrum, a participant commented that the open discussion is valuable because once you have an initial filing, there's going to be litigation.
So do you perceive that as evidence that some participants found more value in the stakeholder process, or at least in this particular meeting than others?
I do, but I was there in the stakeholder engagement process all along the way. I presented at many of the webinars. I presented at the in-person workshops and had great conversations with many of the participants that thanked me for the process and were very appreciative of the process. So I really don't need that bullet to tell me that many stakeholders found it extremely valuable.
And you're not shocked that different stakeholders maybe came away from this process with different opinions about how satisfied they were about what Duke was proposing at the time or discussing to propose and what they ultimately proposed. You're not surprised by that, are you?
No, sir, not at all. Again, I was there and spoke to some of those folks too. And you know, it's a process. It's an iterative process. It takes time to work through some of these issues. And I'm very pleased with where we landed with our stakeholder engagement process.
Can you elaborate just a little bit about why you're not surprised that not everybody was happy?
Yeah, there were some, folks in the room that I'm going to say took a very negative posture from day one, and that's okay. I mean, I get that. There were others that were much more involved and provided a whole lot of input. So I'm not surprised at that. I understand it.
Thank you, Mr. Oliver. Mr. Tynan also asked you some questions about a hypothetical where the grid improvement plan that's the subject of the settlement was not completed in 3 years. And I think he postulated that it could be extended to 5 to 10 years. You recall that discussion?
I do.
Okay, let's talk about the settlement that's before the commission right now. Am I correct in thinking that's a 3-year agreement?
As far as I'm concerned, it's a 3-year agreement. I don't have that settlement in front of me, but that is a 3-year plan.
It's a 3-year plan, and what it does is it between the parties, it agrees that deferral accounting and treatment, subject to the commission's approval of the settlement, would be granted for certain aspects, the 8 programs that are identified in the settlement, correct?
Yes.
And you intend to implement that over 3 years, is that correct?
We do.
And do you know of anything right now sitting here today that is likely to change that?
I do not.
And if you did try to change it, if Duke did try to change it, presumably they would have a reason for that, right?
We would have a reason for it. And I think I'm going to say one of the more advantageous aspects of in particular, the settlement with the public staff is the agreement on reporting. And, talking about changes as they may come up. There's going to be minor changes to the plan. In fact, I expect our engineers, when they get into the details of design, will find a way to make it better, and improve upon the plan that we have. Not substantially change the nature of the plan, but maybe include more circuits and self-optimizing grid for the same amount of money. I do expect those type of changes, and looking forward to the engineers digging into that.
If there were some material change either to the scope of the programs you were proposing or to the duration of the programs, would you expect that the parties who are subject to these settlements and the commission might ultimately have something to say about that?
I would.
Mr. Tynan also asked you some questions about sort of what I would characterize as the benefit of deferral in terms of the pace of implementation of the program. Could you explain that to the commission a little bit about how those two things are related?
Well, my understanding of deferral, is, let's say it's an engineer's understanding of that mechanism. But my understanding is that it allows us to finance these incremental programs, which is above and beyond our normal base, which means we can implement them faster. And when you are able to build a specific team to implement these type of programs, it's simply more cost effective. We've done this type of work before, both large programs, I would say, both in the Carolinas jurisdictions and in our other jurisdictions, and we know how to implement it. A defined budget with a defined scope makes a huge difference in being able to effectively implement the programs. You can engineer the work up front. You can get better, more cost-effective bids because you've engineered the work up front. All of it flows together nicely when it's a comprehensive plan that is known well in advance.
And if you don't have that, what is the situation?
It's a non-optimized work plan. It is, we've not brought the incremental crews in that are dedicated to do this work. So you do it when you can. You do it as available. You do it when there's budget money as available. The work may not be engineered on the shelf, may not be able to bundle it together properly to do it in the most cost-effective fashion. But that's how we would implement it if we didn't receive the deferral accounting treatment.
Thank you, Mr. Oliver. Chair Mitchell, that's all the redirect I have for Mr. Oliver.
All right, thank you, Mr. Jeffries. We are getting close to the end of our day, but I'll go ahead and open the floor for questions from the commissioners and see if we have any. Commissioner Brown-Bland.
No questions at this time.
All right. Commissioner Gray.
No questions.
All right, let's see. Commissioner Duffley?
I may have a few questions tomorrow morning.
Okay, Commissioner Hughes.
I have quite a few of my own and some staff ones. So I'm not sure if I should get started this afternoon, but I can throw out a few if you would like.
All right, well, why don't we do this? Let's go ahead and recess for the day. We will go off the record now. We will go back on the record in the morning at 9:30. We will begin with questions from the commission. All right, thank you, everybody.
Thank you.